From the supplementary cost list for judgment, item number 33.
For the reasons stated above, I do not find any infirmity in the finding of the trial court in this regard, and therefore no interference is required to the judgment and decree of the trial court. In view of the above, the appeal stands dismissed.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 27, orders.
Yes.
Your Lordship, the respondent number 1, V. Koza, Kezo, the Commissioner, Secretary of Health and Family, we received information that he retired last month. So, allowed us 1 week time to implement the new Commissioner and Health Secretary, Lordship.
Mr.
Laknepom.
Lana Counsel for the petitioner submits that the respondent number
1.
one retires last
Last
he has
month,
an
on
information-
31st of
received an
August.
Information that the respondent number 1 has retired last month,
31st of August, yes, sir.
31st of August, and prays for some time to implement the new incumbent in the instant contempt petition. The prayer is allowed. This is matter after 2 weeks. Okay.
Obliged, Lord.
Yeah, please, your lordship. I beg to mention hearing item number 32. 32.
Yes.
Yes, kindly list this matter after a week, lordship.
You are for?
I'm for the petitioner.
Okay. You have no objection. On the joint prayer made by the Rana Council for the parties, list is made after
A week.
a week. Okay.
Much obliged.
Yes, please, Your Lordship, I make a motion for item number 5.
Item,
Yes, Lordship. There's an urgent matter in Court 1, my seniors listed in Court 1 hearing matter. Kindly list this matter after 1-5.
Miss
Vikono Kison.
Rana Council for the petitioner. Why adjournment? Why you said?
My seniors in his lay in Court 1.
Oh, the matter has not yet been called. Wait for
Oh.
some time. Okay.
May I please, Your Lordship?
Yes.
I'd like to mention item number 20, 21, and 22. May this matter be listed after 2 weeks, Your Lordship.
You're for?
The petitioner.
Your Lordship, I'm appearing for respondent 1 and 2.
1 and 2.
Yes, Your Lord.
No objection.
Yes, no objections.
Okay. On the joint prayer made by the Rana Council for the petition parties, list is made after
2 weeks.
2 weeks. Okay.
Much obliged.
Much obliged.
Please, Your Lordship, I beg to mention item 30 on the consensus of both the parties.
19.
3030.
Change it.
30, yes.
Yes,
If this
I'm
matter,
here for the respondent, Your Lordship.
you
A
have
fixed date,
date.
a date may be fixed, Your Lordship, 23rd September.
23rd September.
Okay. Miss,
Krovitz on behalf of Imkong Jamir.
okay, appear on behalf of Konjab and Mr. You're for,
Respondents.
okay. For the, his name, for the respondents, on the joint prayer made by both the Rana Council for the party, list is matter on
23rd September.
23rd September, okay.
Much obliged.
For motion, item number 1.
Yes. Yes,
May I please, Your Lordship. Lordship, this instant petition is filed under Article 227 of the Constitution of India, challenging the impending order passed by the Honorable District and Sessions Judge Dimapur, dated 05/04/2024, wherein the ad interim injunction dated 14/9/2024 passed in IS Civil number 69 of 2023 was to remain in force till the arbitration process is completed. Your Honor, Your Lordship, the apex court has held that when there is an arbitration clause,
what is this?
the relevant para is in para 10, Lordship.
Yes,
Once there is an agreement between the parties to refer the dispute or differences arising out of the agreement to arbitration, or in case other party ignoring the terms of the agreement approaches the civil court and the other party in terms of Section 8 of the Arbitration Act, move the court for referring the parties to arbitration before the first statement on the substance of the dispute is filed. In view of the preemptory language of Section 8 of the Arbitration Act, it is obligatory for the court to refer the parties to arbitration in terms of the agreement as held by this court in P. Anand, Gajapati Raju and others versus PVG Raju and Anand and others. Lordship, we have filed an IA number,
You have filed IA.
yes,
Where?
in the Learned District and Sessions Court, Dimapur. Number
Filed IA for what?
for arbitration under section 8.
Okay, okay.
And in that order, the court have allowed the ad interim injunction to continue till the arbitration closes. Arbitration is over.
In the IA filed by you,
Filed by you.
interim
By
order
us.
was passed.
Interim order.
In your favor or?
No, against our favor. The court, in the order, which is in page 12, Lordship. The order of the district and sessions. Judge. May I read your honor?
Yes, which one?
Lordship, at,
Yes, relevant.
number 4, page 14, the relevant portion.
Yes,
Number 4.
yes.
I have considered the above rival submission advanced by the learned counsel for the parties. In view of the aforesaid submission by the learned counsel that the respondent plaintiff are not adverse to arbitration, I am not inclined to go into the merits of the case and ascertain whether the instant application for reference is maintainable or not, whether the jurisdiction of this court has been ousted by the clause 29 of the general terms and conditions of the agreement dated 24/5/2018. Suffice to say that I am of the opinion that the respondent plaintiff have not concealed any material fact as alleged by the applicant while obtaining ad interim injunction dated 14/9/2023. The general terms of the conditions and conditions of the agreement dated 24/5 has been annexed to the plaint as Annex 5 as submitted by the learned counsel for the, there is no mention of arbitration independent as the present dispute arose after termination contract and the arbitration is no longer binding. Your Honor, no. Yes, no, no.
Interim order was passed in which?
The interim order
This
was
IA or
passed on 14/9/2023.
not in this IA?
In this IA, the interim order was extended till the arbitration clause.
And an interim order was passed in another IA.
Yes,
Where
I sent this.
where the interim order was passed?
In IA 69,
Filed by,
fined by the opposite parties.
okay, and that interim order has been continued here.
It has been continued here. When the matter should be on arbitration.
Okay, Mr.
Therefore, Lordship, the.
Will you notice?
Yes, we have filed an IA. Want to IA in this to add interim prayer is to stay the order passed by the learned district and session judge.
Will you notice first?
Lordship,
Mr. Mr.
Kevin Agil, Lordship.
Kevin again.
Lordship, if this order is not stayed, it will affect us.
When the order was passed?
The order was passed on 5/4/2024.
14/9/2024.
That is the IA passed, filed.
That
by
has
the-
been continued by this.
Yes, by this order,
See,
5/4/2023.
order was passed long back, 14/9/2023.
Lordship.
That-
And we have filed an IA. And the order, we have filed an IA to refer the matter for arbitration.
Okay,
The other party also agreed
yes.
for arbitration. So once the arbitration
By
is,
this order dated 24/5/2018, the said interim order has been continued.
Lordship,
What does it say? 24/5/2018, it was passed.
Your Honor, it will.
Okay, Mr. You are Mr. Kevin Nagi?
No.
Kevin Nagi,
Kevin,
I'm counsel for the petitioner. Sarah. This is an application under Article 227 of the Constitution of India. Praying for setting aside
Lordship,
the impugn order dated 5/4/2024, passed in IA 76/2024 in civil suit number 3 of 2023. Arising out of civil suit number 3 of, no. Okay, that IA 76 was, 76. Okay, arising out of civil suit number 3 of 2023.
Your Honor,
Wherein, no, sorry, wherein the Line Trial Court was pleased to refer the matter to arbitration. So it is submitted that while referring the matter to the arbitration from the Line Trial Court has directed that the aid interim injunction dated 14/9/2023, passed in IA within bracket civil bracket close number 69/2023, will remain in force till the arbitration process is completed. Start. Stop. It is submitted that once the parties have been, are referred to arbitration, the civil court, the civil suit number 3/2023 was not maintainable and liable to be dismissed. And once civil suit number 3/2023 was dismissed as not maintainable, the IA number 69/2023 stand dismissed automatically. As such, sorry. But however, by passing the interim order for continuation of passing the interim order for continuation of the earlier interim earlier injunction dated 14/9/2023, the Line Trial Court has exceeded the jurisdiction, Okay, vested on it, huh? Okay. Stop. Para. Issue notice. Returnable by 4 weeks, huh? The petitioner shall take steps upon the respondent by a registered post with AD within a week from today. Stop. Para. So you filed a separate IA.
Yes, Lord. For at interim two, because they have given us a notice. Mail. Dated 19 July. Which is in page 9. If the operation of this order is not stayed, Your Honor, they will be filing contempt against.
Hmm?
They will be filing contempt against us. If the operation of this order is not stayed, they will be filing contempt against us, which is annexed in IA 127, page 9. That is the email they have sent to us.
127.
In IA 127, in
IA
page
127.
27.
What is that?
This is the ad interim prayer. In page 9, they have.
127.
Yes.
Page.
No, IA. Page 9.
Okay. Yes, yes. IA is there.
Yeah, the page 9 is the letter, email that they have sent to us.
So if this stays, that means then your notification will remain.
We have debarred the opposite party from participating in our tender for a period of 3 years because of some complaint.
What the notice said? What the notice says, this notice issued by.
Yes, may I read, Your Honor? We write to remind you of the Honorable District Court order dated 5/4/2024 directing the immediate removal of the plaintiff name, that is MS Sana Enterprises, from the vendor debarment list on your official website. This directive is to be followed until the arbitration process is completed. Kindly ensure compliance with this order without further delay. Attached is a copy of the court's order for your reference, anticipating your prompt attention to this matter. Your Honor, in the apex court decision, the jurisdiction of this court, civil court has been ousted, Your Honor.
The interim prayer shall be considered on the next stage. However, having regards to the contention and the submission made by the Rana Council for the parties, the impugn order dated 5/4/2024, 4/2024, passed in IA number 76/2023, and civil suit number 3/4/2023, by the Lana District and Session Judge Dimapur. To the extent by which aid interim injunction granted wide order dated 14/9/2023, passed in IA number 69/2023. made to be continued till arbitration proceeding is completed, is hereby stayed till the next date. Okay.
Much obliged. Deeply obliged.
For motion, item numbers 2 and 3.
May I please, Your Lordship?
Yes.
Your Lordship, this is an application for impleadment of Engineer PM Nao as respondent number 5 in the contempt petition. Your Lordship, in view of the retirement of respondent number 5, respondent number 4, Engineer PM Nao was given promotion as Engineer-in-Chief NPWD.
Okay.
So I filed this application to implead Engineer PM Nao as respondent number 5.
Miss,
Alitosu.
counsel for the petition. Staff. Para. This is an application praying for impleadment of Engineer P. Imna, comma, Engineer-in-Chief, NPWD, Nagaland, as respondent number 5 in civil original contempt petition number 28, 2022. Staff. Staff. The land counsel for the petition submits that during the pendency of the contempt petition number 28, 2022, the respondent number 4 retired from his service, and in his place, Engineer P. Imna Ao has been posted and given officiating promotion to the post of Engineer-in-Chief, NPWD, hence pray for this impleadment as respondent number 5 to the civil contempt petition number 28, 2022. Staff. For proper adjudication of the case, Staff. Upon consideration, the prayer is allowed for him, allow the staff. Let Engineer P. Imna Ao, Engineer-in-Chief, NPWD, be impleaded as respondent number 5. With the above this, I stands allowed and disposed of. The main, Miss, name, staff. In view of the order passed today in IA number 126, Engineer P. Imna Ao is impleaded as, has been impleaded as respondent number Imna Ao, Engineer-in-Chief, NPWD, has been is impleaded as respondent number, has been impleaded as respondent number 5. Start. Start. the petitioner shall amend the post title by inserting the name of the newly impleaded respondent number 5. Start. The petitioner shall take steps upon the newly impleaded respondent number 5 by within a week from today by a registered poster with AD within a week from today. Start. List is matter after 3 weeks. Okay.
Much obliged.
Yes.
From the supplementary cost list for motion, item number 34.
No one appears. Who is for the petitioner? Okay. List is on Thursday. No one appears on call. List is matter again on Thursday. Okay.
For motion, item number 35.
Item? It's all the same. 34, 35 to 39. Similar order, huh?
For admission, item number 4.
Yeah, please, your lordship.
Yes.
Lordship, the leading counsel for the petitioner, due to some personal difficulties, couldn't be able to attend this court premises today. Let the matter be clearly come up on 4th November 2024.
When? When do you want, you said?
The leading counsel, due to some personal difficulties,
Okay, when do you want?
4th November.
4th November, as a fix. You have any,
No, my lord. My lord, I'm for respondent number 2.
Mr.
Injunction.
Learned counsel for the petitioner submits that his senior has some personal difficulties due to which he could not appear in the court today and prays for listing this matter on 4th November. The 4th,
Lordship.
Yes.
4th of this,
November
Okay.
11, 4th 11.
to which the learned counsel for the respondent has no objection. 4th November,
Yes, lordship.
okay. Why November? Not even October.
Lordship, I'm not the counsel in this case.
Okay, that is why I'm
appearing-
saying.
Yes, lordship.
May it please your lordship, the other counsel, he is someone who comes from
So-
outside the state.
Okay, okay, as prayed for, comma, list this matter on 4th November, okay.
For admission, item number 5.
Yes,
Yes, your lordship. Lordship, let this case be listed after a week.
after a
Week.
week,
Yes,
you're
sir.
for the petitioner,
Yes, lordship.
as prayed for by Miss
Economic is.
Learned counsel for the petitioner, list this matter after a week, okay.
That's okay.
Yes,
For admission, item number 6 to 11. 6 to 15.
15.
This is lordship.
Yes,
Lordship, as per the last order.
Hmm.
Lordship, in WPC 196.
Some new development has taken place.
Yes, Lordship. And we have filed our IA on the 30th of July. However, it has not been listed today. And I am representing a total of 9 respondents in 4 WPCs. There are 11 WPCs here, Lordship.
Hmm.
And some WPCs are not being listed today. Only 191 and 192 has been listed from the 4 WPCs. 188, 196 has not been listed today. These are all analogous matters.
Okay. You are Mr.
Nongosa on behalf of Naksung Tila.
Oh, Mr. Nongwon.
Yes, Lordship.
Appearing on behalf of Mr. Naksung Tila.
Yes.
Land Council
For the private respondent.
Oh, you're for the respondent.
Yes, Lordship.
For the private respondent in
4 WPCs, 188, 191,
In
192,
WPC
196,
188, 191, 192,
1 and
and
196.
196,
Lordship. Lordship, for selected respondents.
and submits that you have filed what?
We have filed an IA for deletion of
Okay.
for
That-
deletion of name of one particular
It is
respondent
filed an IA in which one?
in
which
one
case?
WBC 196 of 2023.
In 196 of 2023. However, same has not been listed today.
Lordship.
Okay. And you are for,
For the petitioner.
okay, his name, huh? First. Mr. You're up. Okay, non-counsel for the petitioner is present. Start. Okay. Then. So other WPC has also been listed in along with this. So who appears for the others?
Yes, Lordship, I'm also appearing for some respondents in some
Okay,
WPC.
so they have filed IA also. It has not been listed. So it will be listed along with IA.
Yes.
Next date. Okay. Mr. Elira Lulana Council appears for the private respondent in WPC mentioned here. I think this is correct. The last order is correct. Okay, mention this one, huh? And Mr. Amis?
Provisional.
Lulana Council appears for the private respondent
Yes, Lordship. I'll pass.
in WPC. You have mentioned, give the number.
Yes, Lordship.
Okay. Para. Is prayed for by Mr. Nongosa, Land Council for the private respondent. From a list is prayed for by the Land Council for the parties. List is matter. After,
Lordship, after a week.
along with the IA. Number do you have? IA number, okay, along with the IA filed by the respondent, private respondent number, respondent in WPC 188, 191, 192, and 196.
No, Lordship, the
What
IA
is-
is only for 196.
Okay, 196, okay. After list,
Lordship, a week. After a week.
1 week.
after a week, okay, after a week, okay.
That's not.
For admission, item number 16 and 17.
Please, madam. This is my revision petition, my lord.
Yes,
There are 2 revision petitions in this case. One is revision petition number 1 of 2024.
just.
Please. I'll go very slowly because it's a little voluminous. I will explain it.
Just a minute, this is IA. Which one we are going to take up now?
There are two revision petitions. One is CR number 1 of 2024,
One.
and the other is CR number 2 of 2024.
Okay.
To
this-
begin with, let us take CR number 2 of 2024.
CR number 2. So item 17.
Please.
CR 2.
May I just give a small background of this one?
Just a minute. Huh?
Okay.
We are taking up CR 2.
2.
CR 2. Okay, just a minute.
Actually, CR 2 should have been the first, but in the numbering they got it like this. That's it.
Okay. Yes, CR 2.
Yeah. To give a brief background, these petitions pertain to certain lands which are an extension of the airport land, Dimapur Airport.
Yes. Yes.
Captured by these respondents. Consequent to which the state is handicapped from expanding the airport because the runway is very small, coupled with the fact since the runway is very short, the scope of development of the airport is limited, and further, there is serious chances of major accidents happening in the airport. This airport was used during the Second World War, and in time of any national crisis, this is one of the airports in the Northeast which will be activated. That is the significance of this place. Now, my lord, to cut it short, coming to the brass facts of the case. The learned district judge confirmed an injunction order passed by the civil court which restrained these trespassers from being evicted. What is material for us is that when the civil court confirmed this order, the state had no option than to approach this court by way of this civil revision petition. The main case revolves upon this Atosho, late Atosho, I would say, who expired during the proceedings, and he has been submitted.
The main
Party in this case is Mr. Atoshe. Atoshe. After his death, his legal representatives have been made parties. And if your lordship were to see the cause title now of civil revision petition number 2, it is State of Nagaland and 3 others versus Srimati Tohili, bracket Atosho and another. So that is how the family members become parties to this case. Now, my lord, certain documents are relied upon by the original party Atoshe for the purpose of establishing that he had title over the property. I will just take 4 or 5 documents, then I leave the facts and come to the law. The first document, my lord, he relies upon an allotment of land. And that allotment of land is at page 627 of CRP 2. Lordship will got that, no?
Just a minute. 627.
27. It's begin from there. I will be giving you, your lordship, all these in the form of list of dates and submission shortly. It shall be placed for your convenience.
List of that given? No, not yet.
Bitso, Mr. Bitso, kindly hand the word. Same thing is already on record, just I have paginated it according to both these cases, nothing else. Now in this, I'm coming to paragraph 3 of these written submissions. My lord has got that, my lord?
Yes, para 3.
3. Plaintiff claims he was allotted land wide order dated such and such 27/10/1993. The letters pertaining to the temporary allotment are at page 627 to 629 of CRP number 2 of 2024. My lord may forget volume because that has been done for our convenience. Kindly see 627, my lord. 3 pages. My lord may come to 627.
27?
627 of this CRP 2.
Yes.
My lord has got that, my lord?
Yes.
This begins with the letter of June 92 on the top.
Page 27 of the CRP 2.
627. 627.
Yes.
My lord has got that, my lord?
Yes.
That's June 92 at the top. Am I right, my lord?
Yes.
No, I'll just read 3 lines. A plot of land acquired for airport expansion is now for export expansion for which land compensation has already been paid is now left out by the airport authority while putting up security fence as the said area is in the bank of Difu River. It's in a marshy area. The same plot of land is hereby temporarily allotted to be utilized by Sri Suhoto and Sri Hetosho under the following terms. They shall not claim any compensation. They will vacate the land as and when the department airport is required. Now, the effective thing is at page 629. We are concerned with that.
Yes.
This is the letter of 27th of October 1993.
Yes.
The land under DAG number 40 and 38 specified below at Difu are hereby temporarily allotted in favor of the following persons. Kindly note this. Subject to approval of the government. Kindly mark this, my lord. Subject to approval of the government. Under the following conditions. We are concerned with allottee number 1. Atosha Sema. Log number A by 40. The area is given here 9B4K3LS, the Kupa. Now, my lord, after having taken a lot to that, I want to bring to your lordships that this particular land, according to the plaintiff, was regularized in the year 1996, according to the plaintiff. Now, kindly make a note of 1996. Ultimately, my lord, the same land was cancelled by the government.
When?
I'm just coming to that. That is at page 656. Just take out 656. I just too many papers in this. This is at page 656.
Okay.
656. My lord has got that fellow? No, it says 31st May 2005. The land allotted by the ADC Dimapur wide order dated such and such, under dog number such and such, measuring an area of such and such, 9 biga, etc., at the Fupar village, in respect of Sri Hatoshe, that is V. Atosho Sema, is hereby treated as cancelled on the ground that the site allotted to him falls within the acquired land of Airport Authority of India. This has come to a finality. Now, my lord, against this order, he has not filed any appeal. So this order has become final. That allotment which he got in 93, which was supposed to be regularized in 96, whole thing came to an end in 2005. So that chapter of his land is over. Now, my lord.
Yes.
My lord.
Yes.
Thereafter, my lord, after 14, 15 years, they had some dispute and the then commissioner passed some orders against them, which is not relevant as far as Atosho is concerned, because He did not file any appeal against that order also. I'll take your lordship later to the order of 2019. What he does is, he files a civil suit before the civil court. That suit is suit number 22 of 2019. The lordship want to see the written submissions, para 3, my lord has got that, which I had read out to your lordships, the para 3 of my written submissions. Just paragraph above that I have mentioned. If I could kindly take your lordship to that. My lord has got para 3.
Para 3 of?
Para 3 of the submissions which have been placed for your lordship's kind of consideration. Just above that para is, I have written here, Athoso filed civil suit. My lord has got that, my lord.
Yes.
Athoso filed civil suit 22 of 2019, which is at page number 309, Civil Revision Petition 2024, for declaration of rights and titles and perpetual injunction in respect of land covered under Patta 45 under DAG number 40 by 100, 117, refer to page 319. Let's just go only for a minute to page number 309. Same page, page 309.
Page 309 now.
309 of the same body. I am talking only of civil revision petition number 2. I am keeping the other one separate. Otherwise, we will get confused. All this pertains to Athoso.
Please, ma'am.
This is the civil suit. I just wanted to show your lordships.
Yes.
This is his case, all cylinder.
Yes.
Civil suit number 22 of 2019. I'll take your lordships straight away to the prior clause. I won't bother your lordships much on this civil suit at all. Kindly see page 319. Prior clause. What is he asking? My lord has got that 319, man.
319.
Yes.
Yes.
Now, they say para 28 and 29 are the prior clauses.
Yes.
28 says, the schedule of the land are as follows. Plot of land measuring such and such by patta number such and such under DAG number 40 by 100 and 117. I'll come to that 117. Situated in Difupar village, Dimapur, Nagaland. The land is bounded by these things. 29. He prays for a declaration of rights and titles of the plaintiff in respect of his land, perpetually. That's it. So, he is asking for title to a particular property. This particular property. So once that is his case remains there at this only. May I continue, my lord?
Yes. DAG number 40
by 100
and
117.
okay.
40 by 100, earlier it was A by 40, 40 by 100, and what is 117, I'll explain.
Okay.
Now, where does the dispute begin? The dispute begins on the ground that another party called Vinoka, that your lordship may not go to the other petition, and just for your lordship's assistance, I'm saying that he is the party in CR number 1, Vinoka. We'll take up that separately. Vinoka claims that he purchased the property belonging to Atoshe from Atoshe. So this is where the dispute starts, and this is in the year 2015. Now, my lord,
Just a minute. This last point I didn't get. Vinoka Chisi.
Vinoka is the party in civil revision petition number 1
Yes.
that we are yet to take. We'll come to it separately.
Okay.
No, he says that I purchased in that petition, which I'll come to subsequently. He says I purchased one particular land, that is the same land, from Atoshe.
In who is in a civil revision 2?
Yes. So civil revision 1 says I purchased from civil revision 2. Why I'm bringing in intermediately that civil division 1 is because if you see the entire plaint from 309 to 319, Atosho does not say he sold any property to anybody. He does not even mention the name of Vinoka. That point I want your lordship to note. That's whole plaint. He doesn't speak that I sold the property to this man.
Yes.
Now, my lord, though the chapter of Atoshe came to an end in 2004, he again reopened his case in 2019, claiming title over A by 40 and 117. We are not seriously concerned about that, but I have to place this on record. Now, my lord, because of rampant encroachments of airport land, the airport authority started complaining to the government to throw out the trespassers. This is from 2015 to 2019. And the complaints are on record. And I will draw your lordship's attention to it shortly.
Yes.
So, my lord, the commissioner at that time called all these parties, checked their title deeds, and found they don't have title deeds over dog number 38 and 40. Now, kindly make a note, mention of this, 38 and 40. This is the trespass area which they are holding on to. Dog number 38, dog number 40.
So, 38 is not here.
38 is not there, 40 is also not there.
Hmm?
38 and 40 dog number,
Hmm.
they are large pieces of land.
Hmm.
When you say A by 40 is a small portion. I'll clarify that just in a minute. There's no confusion. When the commissioner passed an adverse order against all these persons, I will just take your lordship through various proceedings. Atoshe, the original owner, who filed that civil suit which I have drawn your lordship to, he didn't challenge the order passed by anybody.
Did not challenge.
No. And he is the man who can speak about the land up to the end. Because Minoka comes into the picture only in 2015. Minoka files a writ petition in the High Court. I'll give a detail of the proceedings, just for your lordship's understanding. And in those petitions, he admits positively that he is not the owner of dog number 38 and 40. I will draw your lordships to the different paragraphs in which he makes this admission. And ultimately, my lord, after making all these admissions, the court, on the basis of these admissions, modifies or makes a little bit change, saying you can remain at Akrani Patar where you are claiming title to the property. So no dispute. It's basically an order on consent. It became final. Later, Minoka withdrew this petition. I'll give the chain, my lord. These are not. He files a writ petition first
Minoka filed writ petition.
in the High Court.
Hmm.
Then he makes certain admissions that he himself says, I am not the owner of that airport land. My land is at Akrani Patar. So the High Court passes an order. Since he is claiming he is at Akrani Patar, don't disturb him at Akrani Patar. But he has no right over dog number 38 and 40.
On the basis of his admission, what did he, who passed order?
The single Justice Herodo passed the order.
No, what order was passed?
Please, sir.
So,
Please, Your Lordship.
yes,
My lord, the Learned Advocate General is mixing up both revision petitions now.
But I am not taking up. Please don't interrupt like this. Let me complete my submissions. After I complete my submissions, you can interfere, please. I'm not making any, I'm not making any sum. Please wait. You'll get your turn. No, my lord,
so the, what order was passed?
the order was passed by Justice Seroto.
No, what
That
order?
is on page 449 of Vinoka Chishi's petition. Now, your lordship may take CR number,
Page number?
page number 449 of CR number 1. Now I am coming to CR number 1 because Minoka has come into the picture. We'll take CR number 2 aside for the moment. CR number 1.
So after passing order in, which is in 449,
Right.
Vinoka withdraw the writ petition.
Here is the, I will just take your notice straight to the final prayer clause. It says, page 464.
Page 464
Of Vinoka's CR number 1. Same. Seroto's order only. The last page, your lordship wanted to know what order was passed.
464 is same in the CR number 2 also.
No, it is, no, this is in CR number 1. I am coming to CR number 1.
CR number 1.
Yes. My lord has got that, my lord? Last page?
Just a minute, 464.
Yes.
Yes.
They say that it may be mentioned, learned AG had even submitted, petitioner is not going to do anything in respect of doc number 79/96 of Egrani Pata for the time being. Only prays for modification of the order in respect of land under 3840 situated such and such that the petitioners will have the right to claim compensation in case they are successful in showing their right and title over 38 and 40. In view of the above, I am of the view that interim order stands manual status quo shall only remain in respect of land number 36. So just pause for a moment, please. After this order was passed, they again approached the High Court, withdrew this petition with the liberty to file a fresh petition, and that is at page 469.
Just a minute, huh?
Page 46, same thing, continuation. First, they filed the writ petition.
Of the land on the lab number 79. Money for the, and not for the land. This was disposed.
These were disposed. Then at 469, liberty was given to him to withdraw. They withdrew the petition, filed a fresh petition. After filing the fresh petition,
Just a minute, what was this, withdrawn? Writ petition?
yeah, the main writ petition was withdrawn.
Okay, then this was, or, this order was passed in
Page 469, which I just read out to your lordships.
464 is order in
464 is the order in the main writ petition where Justice Seroto passed the order. 464.
Just a minute.
Right. My lord has got that, my lord?
Just a minute, huh? So this 464
My lord.
is, this is IA.
IA. We filed an IA.
No, so 464 order is in IA.
That's an IA.
Okay. So the IA
No.
goes off by this order.
IA was disposed of. Thereafter,
Okay.
at page 469, they withdraw the entire writ. Can you see 469? My lord, about 469, my lord.
Just a minute. Yes. Yes.
Now, here he withdraws the entire writ. Last page. Accordingly, petitioner is allowed to withdraw the present petition with liberty to file a fresh petition. My lord has got that, my lord?
Yes.
Now what he does, he again goes back to the court and kindly come to page 473.
Yes.
Now in page 473, there is an order of 11th December 2020, again by Justice Seroto. He seeks liberty to withdraw and go file civil case. Kindly see. My lord has got that, my lord? Here.
Yeah.
Now, it is written, from the submission of the learned counsel of petitioner, it appears prima facie that this is a fit case for approaching the civil court. Therefore, petitioner may approach the civil court, petition is disposed of. My lord has got that, my lord.
So the petitioner
My lord.
was directed to approach the civil court.
That's right, my lord. Sorry. So
Yes.
now we come to the actual action. This is just to show your lordship where all they went and what all they did. Now we come to the main point. He comes to the civil court.
Just
Now,
a
my lord.
Just a minute.
Yeah.
Yes.
Now he comes. Now he files a civil case. That is on page 3 of my written submissions. Kindly see page 3, my lord.
3 of?
3 of my written submissions, where I have said that this is a brief narration of the facts of this case. Now it says, Vinoka and others, this party who traveled through various courts and withdrew, he filed civil suit number 14 of 2020. 14. This suit of his
Just a minute.
to 6,594.
Para?
Page 3, the last, where it is underlined, the above is a brief narration of facts of the case.
Okay.
Below that it is written, though it is Vinoka and others who are the plaintiffs who filed civil suit, I'm talking of civil suit number 14 of 2020. My lord, got that, my lord?
Yes.
Now I take your lordships directly to this civil suit which Vinoka has filed.
Vinoka means civil suit.
That is the CR, that is CR number one, that party,
CR,
CR one. Vinoka, CR one.
page,
I'm just coming to the page. This is that page.
this is for admission today.
Yes, sir.
These two are connected. I'll come to that point. Now, kindly see page 346. This is the suit filed by Vinoka, and this 346
Of
is
CR
in
one,
his, is in his CRP,
346 of CR one.
CR1. Correct, madam. I'm sorry, my lord, I'm forced to take your lordships from one to the other. Table 346.
This is.
It's a little difficult, my lord, but I'll finish this off. This is only giving a background. Law is something separate.
346.
Yes.
Yes.
Now, here is his suit. My lord, you got that, my lord?
346 page.
Yes, 346 is the suit number 14 of 2020.
Yes.
Now, if you go by 14 of 2020, without going into much materials of this, I'll take your lordship straight to the prior clause.
Suit number 14.
Yes.
Yes.
Your lordship could see, he's challenging. Lordship has got that, my lord?
Yes, page.
Page 364.
Hmm?
364 is the prior clause of this suit, last page of the suit.
Yes.
He is asking for various reliefs here. The lordship, declaration, eviction order, order passed by the commissioner, declaring to compensate him, costs, etc. But he is not asking for title. Kindly mark that. He should have asked here, I am the owner of dog number 38 and 40. I have a title to it, just like how Atosha has asked. Atosha has asked for A40 and 117. So he should have asked for that. He does not even ask for title because he has no title. Now I'll come to the real.
This was filed subsequent to the direction of the court that.
Correct, madam. Correct, that's right. The court said, okay, you go write civil court, and in that the pleadings have come that if in fact we have made a statement, if he proves his title, he will get compensation. Now he is not talking about title. Now, how does he speak about the title? Lordship would see that he has filed in the same brief a series of sale deeds and gift deeds in the same petition to show he has title. And these are page, kindly make a note, my lord. This I have mentioned at page number 3, same page number 3 of my written submissions.
Just a minute.
Para 6. Para 6. It's right at the top.
Just a minute. 14 of 2020.
My lord is para 3, my lord. Page 3, page 3 of
Three.
my written submissions.
Yes.
Page 3 of my written submissions.
Hmm.
I will just read out para 6 of this. The
Yes,
second para. We may now, may I read it, my lord?
yes, please.
We may now analyze the role of the remaining trespassers, namely Binoka and others. They filed suit number 14 of 226, which is Annex 3 at page 346, civil revision petition, which I've just mentioned to your lordships. I've also shown your lords that the prayer clause is at page 364, in which he has not even sought for declaration of title. He could not do so because he has no title. Now, he has placed on record various sale deeds purported to have been executed in his favor, which are in CRPC, same CRPC, at page 776 to 871. Kindly mark that, madam. A bunch of documents, 776 to 871. They are the sale deeds which have been filed by Binoka Cheshi. They don't contain the name of Atosho, nor the sale deeds show the property is located at Digupar 38 and 40, whereas the locale of the property is shown as Ekrani Patta. Kindly see, madam. This is the point. Now we are actually in the main area, the suit. In his pleadings, he says, I purchased this, and these are the sale deeds.
Yes.
No, my lord, just to take your notice, just for a minute, if you don't mind, my lord. I'm handicapped because I'm here, otherwise I would have opened it for you, lord. Page 776, kindly take. 776. Same CR number 1.
CR number 1.
I won't take any more pages. I've been rest assured. Only to give a background. I'm sorry I'm putting your lordship to you,
776.
jumping from one file to the others, but the documents are such a lot. Page 776.
Yes, schedule.
Yeah. Now you just, your lordship will see, I have, the documents are from page 776 up to 871, 120 pages. I'm just taking out one document for 2-3 pages. Your lordship can see any of the documents, they are on the same terms. Some are sale deeds, some are gift deeds, etc. May I read it, my lord? Just for first page.
Page 776 is continuation of sale deed at 775.
Yes. Now you have 776, that is a sale deed. The sale deed, your lordship will have 2nd October 2015. I hope my lord has got that, my lord.
It is in 775.
775. In fact, some of the papers of sale deed, it is written there, but the actual sale deed is in the next page, 776.
Yes, schedule.
That's right. My lord has got that, my lord?
Yes, schedule.
This sale deed is at Dimapur on 2nd of October 2015.
Yes, at 775.
At maybe 775, maybe my pagination may be a little this. I'm sorry, my lord. Now, what is important here is kindly see, whereas that is 1, 2, 3rd, 4th paragraph from top. Whereas the vendor, my lord has got that, my lord?
Yes.
Is the sole and rightful owner of a plot of land measuring so much, bearing patta number 726, dag number 76, Mauza number 76, situated at Ekrani Patta.
Yes.
There is no talk of dock number 3840 of the airport. Lordship would see, madam.
Yes.
So all these documents speak of Ekrani Pattar. All. Oh, 1661.
Yes.
Now, when he speaks of all these documents, because he has got title deeds only of Ekrani Pattar, he does not ask for title declaration of title in his suit, civil suit. Can you see? Because what he has is only Ekrani Pattar. So what does he say? I'll draw your lordship. He himself will point out to your lordships. He says, my actual property was not in Ekrani Pattar, but it was in dock number 38 and 40. That surveyor wrongly wrote it. No, surveyor asked him to write like that. Lord, see, his defense, he will come to it. This is a written document. The written document says he purchased land at Ekrani Pattar. That is separate. I will show the map. Ekrani Pattar is separate and the other area is separate.
Ekrani Pattar is separate and?
And this Diffufat dock number 38 and 40 is separate.
Okay.
I will show that. The river, etc. Then, my lord, what they say, when they are confronted, even by the court, how do you explain this? They say the surveyor made us write that, so we wrote it. That's no defense in law, man. Because if you see section 60 of the Evidence Act, 60, it says, it speaks of oral evidence. And it also says that written evidence cannot be substituted by oral evidence. Not 60, section 92. I'll just read out section 92, your lordship may just mention. This is their defense. Their defense was, actually it was wrongly written as Ekrani Pattar. This is what they say. So section 92 of the Evidence Act says, if there is a written agreement, you cannot lead evidence to the contrary by oral agreement. So you cannot take that stand. Section 92. Evidence Act.
So, who says that it was?
He himself says, Binoka says that in writing this, it was wrongly written.
Who says, Vinoka?
Binoka, that is the plaintiff. Plaintiff says that is his case. That is his case throughout.
Okay.
Now, we will leave all this behind.
Where he says, where he says that it was wrong?
Yeah, I will just point that out here. It's part of the record. Let's not dispute it. That's his case. That is at page 355. Same civil revision petition number 1, page 355.
Three 55.
Please, madam. 355, para 5. I won't read any more paragraphs, my lord. I assure your lordship, I will come back to the legal point. CR number 1, my lord.
Okay. Yes.
May I read para 5, my lord, of this 355? May I read, my lord?
Yes, please.
The plaintiff says performer defendant by way of gift sale. Performer defendant means Atoshe, from whom he is supposed to have purchased it. Atosha is the one who was there in CR2. He says performer defendant by way of gift sale transferred to them the respective plot of land from his registered land at Difufar village. Thereafter, the plaintiffs applied before the office of defendant number 3 for transferring and mutating their respective plot of land in their name. Accordingly, the office of defendant number 3 conducted spot verification and advised for mutation of their respective plot of land from the registered land of the performer defendant number 6. The surveyor from the office of defendant asked the plaintiff to prepare their respective sale deed or gift deed showing their land situated at Ekranipatta. Accordingly, as advised by the surveyor, the plaintiffs prepared their respective sale deed showing their land located at Ekranipatta. The office of the defendant number 3, on the basis of the sale deed furnished by the plaintiffs, mutated their names and issued their respective Jamabandi. Plaintiffs have never requested to convert their land document to that of Ekranipatta. Document as submitted should be in the office of such and such. So this is the way he is trying to say. Just see the type of game they are playing with government property. They say we are owners. They are given liberty to file a civil case. They don't ask for title. They file some other property documents. And then they say, actually, it is not Ekranipatta, it is here, dog number 38 and 40. That surveyor told us so, only we did it. Therefore, my lord, in this connection, your lordship may kindly see the Evidence Act, section 62 and 92. Only 1 minute, my lord. I'll just read it out. Your lordship knows this. I'll just read it out. I'll read it out for your lordship. Exclusion of evidence of oral agreement. May I read it, my lord?
Yes, please.
When the terms of any such contract, grant, or other disposition of property or any matter required by law to be reduced in the form of a document have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representatives in interest for the purpose of contradicting, varying, adding, or subtracting from the terms. Why? Why we have this section? So that people don't tell like these things after executing a document, I did it because of this and I did it because of that. That is why I say you reduce it to document writing. Once you have reduced it to writing, now you can't get out of it. Now I leave all these papers. I won't trouble your lordships on any of these papers. This is only to show your lordship, how they are playing with the government property, which is a very big tragedy. They cannot take the government for a ride. After all, it's a public purpose. You require an airport. Now to take away the benefit of the public, a few trespassers squat on it and they're demanding compensation. Give me compensation. Government is saying, we'll give you, prove your title. They are not proving title. Now, my lord, after having placed before your lordships these facts, what ultimately emerges? My first legal point is there is no dispute as far as title is concerned in this case. Kindly make a note, my lord. There is no dispute. Why there is no dispute? Minoka himself is not claiming title to any property. Unless he says, this is my property, he files a title suit, there cannot be a dispute. What he relies upon is certain sale deeds which does not pertain to DAG number 38 and 40. Number one. Minoka says, I purchased the property from Atoshe. Atoshe in his suit does not say, I sold the property to him. So therefore, if there is to be a dispute to title, Minoka should also say, I have such and such property. He doesn't say that. And Atosho is not claiming DAG number 38 and 40. He is saying A by 40 and 117 that I will deal with separately.
DAG number 38, he did not sell.
No, he has to show he's squatting on DAG number 30 and 40. They have captured that. Though they have only a few houses, I have surveyed this myself. I've been there. I'm getting the drone photography of this done, which will show the real game they have played. Now, after having taken your lordships to all these facts, let us take it for the sake of arguments. These people had been given title by the Deputy Commissioner. Let us take it. A second line of my argument is this. Though I have established they have no title. Secondly, worst situation. The government has issued various notifications saying the Deputy Commissioner cannot allot land or pattas to anybody except with the permission of the government. And those notifications, my lord, I have filed. And in which case, my lord has got that, my lord.
Okay.
That is, various notifications have been filed by the state, which says, unless you have government permission.
Plus the government has to approve.
Yes, because what these deputy commissioners, officers are doing, random, they were taking government land and just selling it for peanuts.
Without approval from the government.
Without approval. And this was a big scam. So, various notifications were issued. And some of these notifications, your lordship may just make a note of it, page 63 to 633 to 649
Of CR.
CR number 2. I'll get the parallel of CR number 1 also. For the moment, kindly restrict it to this. Then, my lord.
What is there in page 633 to
633, I will just read out. It's specifically written in the notification. My lord has got that 633. I can read it out.
CR2.
This is
CR2.
CR2, my lord. Correct. Plenty of notifications.
Yes, 633 is.
Yeah.
Government
Yes.
notification.
Correct. Now you can just see the para C, bottommost. No allotment of land.
Yes.
No allotment of land shall be made to any private individual society communities by any administrative officer without the prior approval of the government. Don't you got that, my lord? And next page, they said, this is there right from the beginning, right from the beginning.
Yes.
So like this, it also says that if you capture this type of land, you will be pushed out by some certain such unauthorized occupation of the land. So we have a series of notifications which says you must take permission from the government. Why these notifications came into existence was to prevent the officers from being a law unto themselves by selling government property at a cost of peanuts. So my submission humbly is this. Let us take it that the other side says, no, I have got title, I have got this, I have got that. Let us take for the sake of arguments. And that is going to be their argument. Where have you got the permission from the government? So if you don't have permission from the government, that means you have no title. Where is the dispute? Now to cut it short, my lord, 153 or something, that is several judgment. To cut it short, there is a division bench of this Honorable High Court. Exactly on this. And that I have already filed with my petition, CR2. And that is at page 132 of CR2. My lord has got that, my lord?
Yes.
Now, this is a TV judgment. Yes. Justice Sarata and Justice Barro's judgment. So, in this judgment, para 42 of this judgment. And para 42, my lord, just to assist your lordships, it is at page 161. My lord has got that, 161.
Yes.
Page para 42.
Yes.
The power of the Deputy Commissioner for granting allotment of land in terms with the rules thereof, in our opinion, is subject to general or special orders issued by the state government. These notifications would come within the ambit of general or special orders issued by the state government, and the aspect of the matter is also not taken into consideration by the learned single judge in holding that the impugn notifications were ultra-virus regulations and rules framed thereunder, for which we are of the view that the impugn judgment order is liable to be interfered with in the matters as indicated herein below. So, my lord, according to this judgment, this division bench judgment, the single judge has said that these notifications are ultra-virus. The division bench said, no, they are perfectly valid. And you can allot land only with the permission of the government. So detailed judgment, my lord, this one. I think this was in 2022 also. This judgment was of 2022, I think, this one. I had appeared in this matter, I think. So therefore, my lord, therefore, well, they did not have the permission of the government in terms of the notification or the confirmation of the legal validity of the notification by a division bench order. Whatever story they may weave of how they came into possession or whom they purchased from has no effect. They have no title. They are clear trespassers. You cannot protect the interests of trespassers. So I have given two situations. One is on the basis of facts, they don't have title. Two, presuming they have title, in that event, they must have the permission from the government. Once they don't have permission from the government, then what happens? That allotment is illegal. If you take illegally government land, you cannot hang around with this government land under any law. No, my lord, I will take your lordships.
Have you challenged the allotment?
Which one, my lord?
Have you challenged the this allotment?
Who, my lord?
The government.
No, the government is banking upon, yes, naturally, we have said that this is all bogus.
No, whether the allotment given to the petitioner has been challenged.
The allotment given by the petitioner has been given by the government according to them.
No, given
Number
by
one.
the commissioner. Now the government is saying that it has no approval of the government, whether the allotment has been challenged.
That has been explained in our reference also, that this allotment is subject to law.
But no
There
challenge.
there is no requirement of separately challenging these type of notifications. We have to show that they acted against our notifications. So the division bench says, yes, you should have permission from the government, otherwise it is wrong. So there is no need for the government to challenge. They should have challenged the division bench order before the Supreme Court. That order of division bench has become final. So for them to do it, they did not challenge it. That's my second submission. Third, now, suppose, my lord, for the sake of arguments, I give one more concession. Suppose the government has given them permission. I'm coming to the third stage. I have one more point to say, to clarify. Because your lordship just now asked whether you have challenged that notification, I mean that order. This order is relied upon by whom? By them. So if they are relying upon these types of orders, the obligation to prove these orders is on the plaintiff, not on me. If an order has been passed, party is relying upon that order, the owner shifts to me only after he has discharged the burden. So once he relies upon it, he has to prove it. While I am very grateful for this question because it escaped from my mind. If when I'm going to read the various points on prima facie case, balance of convenience, etc., your lordship will be shocked to note that the learned district judge has given a new finding unknown to civil law, that is, the defendant should prove his case.
Okay.
I will read out that. Defendant should prove his case. In fact, my lord, there was a border dispute in Nagaland between Nagaland and Assam, where the Supreme Court appointed a local commission, my lord, here. I was a party to it about 10, 12 years back. So what the local commissioner passed an order that we are the defendants. Defendant, prove your case first. And the local commissioner was headed by a retired Supreme Court judge. I took up the matter before the Supreme Court, saying like this, a retired judge has given a direction to us to prove our case. How can it be? Immediately thereafter, the local commission did not function any further, and the matter was referred to mediation after that. And I am going to furnish to your lordships Supreme Court judgments on these very aspects, which say that you cannot shift the burden onto the defendant. Defendant may have no case, he may have weak case, he may have anything. But the obligation to prove is of the plaintiff. Your lordship knows that it's a very simple basis of law. Here, since they don't have any title, they came up with a plea, you prove your accusation first. My lord, we have to be fair also, my lord. After all, state is also not an illegal entity, it's also a constitutional creation. So we cannot just whittle away the things of the state like these type of observations by the court. Now, my lord, after having taken your lordships to these 2-3 points, ultimately, what are the principles on which we should establish whether injunction can be granted or not, my lord? Prima facie case, balance of convenience, and then ultimately irreparable injury. And in this case, fortunately, one more ground, public interest, that has been added by the judge subsequent to our submissions. Now, I keep those 3 things apart for the moment because I'm going on the legal aspect. I said that 1, they don't have title because they don't have permission. 2, I said, even if they have title, they don't have approval of the government. I had expressed to your lordship a 3rd condition where let us presume the government has granted permission. Everything is lawful. This is not their case. I'm just to explain to your lordship. Then what happens? No, my lord, your lordship may kindly take my written submissions. I have concised it. Page 4. Para B. My
Yes.
lord, important. Para B. Now, I am taking your lordships to the amended specific relief act. And in the amended specific relief act, there is a provision which says injunction cannot be granted in the event of any activity pertaining to the schedule. And in the schedule, they have given road construction, airport construction, so many constructions, including airport. So the statute itself says you can't grant injunction. Now, ours is a case of airport. We are covered also under the statute where you cannot grant injunction. I'll come to that one. To simplify it, kindly see page 4. B, legal submissions in this context. Your lordship has got that, my lord?
Page 4.
Page 4,
Yes,
legal submissions in this context.
yes.
I will just read it, my lord. The impugned injunction order passed by the learned judge, in spite of referring to section 41HA, which inhibits the grant of injunction with regard to infrastructure projects like airports enumerated in the schedule of section 41HA, did not give any finding on this aspect, but on the contrary, granted injunctions against the statute. Now I read, madam. Now coming to the version of Supreme Court judgments on this. Section 41HA of the Specific Relief Act was introduced by an amendment in 2018. The amendment was totally ignored by the learned civil judge senior division below. Now I am coming to a particular decision of NG Constructions, para 19. I am giving the background much. The Specific Relief Act 1963, your lordship has got that, my lord?
Yes,
Was amended by Central Act 18 of 2018 when clause HA was inserted in section 41 of the act to say injunction cannot be granted in terms of the section. 41 HA, if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facilities related thereto or services being the subject matter of such project. Such amendments was in pursuance of the report submitted on 20th June by the expert committee. The expert committee sent on examining Specific Relief Act submits its report to Union Law and Justice Minister, recommends modifications for ensuring ease of doing business. The expert committee submitted its report to the Union Law and Justice Minister, so-and-so. In its report, the committee has recommended modification to the Specific Relief Act for ensuring the ease of doing business. Context of tremendous developments which have taken place since 63 and the present change scenario involving contract-based infrastructure, developments, public-private partnerships, and other public projects involving huge investments and changes required in the present scheme of the Act, so that the specific performance is granted as a general rule and grant of compensation or damages for non-performance remains an exception. I'll just pause here for a minute, my lord. Yes, kindly bear with me for a minute. I'll just explain this concept. So what they are saying is, now if somebody, like you want this land for any of these projects, or some project is going on, at the most, if he proves title, you can give him compensation. So compensation is the rule. and specific performance is the exception. Before the amendment, specific performance was the rule and compensation or damages was the exception. That will be there in the next page. I'll take a lordship now to the next page. To change the approach from damages being the rule and specific performance being the exception to specific performance being the rule, being the alternative remedy. To provide guidelines for reducing the discretion granted to courts and tribunals while granting performance and injunctive release. To introduce provisions for rights of third parties other than government contracts. To consider addressing unconscionable contracts, unfair contracts, committee observed. There is a need to classify diverse public utility contracts as a distinct class, recognizing the inherent public interest, importance to be addressed in the Act. Any public work must progress without interruption. This requires consideration whether a court's intervention in public work should be minimal. Smooth functioning of the public work projects can be effectively managed through a monetary system and regulatory mechanism. The role of the courts in this exercise is to interfere in the minimum extent so that public works projects will not be impeded or stalled. Since the construction of the road is on infrastructure project and keeping in view the intent of the legislature that infrastructure projects should not be stayed, the High Court would have been well advised to hold its hand to stay the construction of the infrastructure project. Such provision should be kept in view by the writ court while exercising its jurisdiction of 226. A word of caution ought to be mentioned here that any contract of public service should not be interfered with lightly, and in any case, there should not be an interim order derailing the entire process of the service meant for large public good. The grant of interim injunction by the learned single judge of the High Court has helped no one except who lost a contract bid and has only caused loss to the state with no corresponding gain to anyone. So this is a Supreme Court judgment, my lord, and I have mentioned this was placed on record during submission. It is again filed here at page 97 to 120 in CRP number 2. The judgment is there. My lord has got that, madam. If you see page 97 of CRP number 2. Okay, CRP 2. CRP number 2, page 97.
Yes.
Don't mix it up, you guys. Don't mix up with the fact.
Yes.
Now, the whole detailed judgment is there. This judgment is called, page 97, NG Projects versus Vinod Kumar Jain and others.
Yes.
We'll just read the top first page that explains everything. Otherwise, it's a detailed judgment. I think for our purpose, this should do. Unless your lordship wants me to read the entire judgment, I can read it.
No.
This gives the essence. Government contracts, remedies, public law, writ remedies, judicial review in cases involving tenders, contracts, public interest, as in the personal construction of roads, construction of roads, restriction of applicants. Now, before I proceed on to this, we have to understand that this is a case where land was acquired by the government for the expansion of the airport. We are not able to go ahead with the airport because of these encroachments and the protection given to these encroachments successively by two courts by granting them injunction. Can you see that, madam? Therefore, our airports also come under section 40 HA, which I will bring to your lordship's notice shortly. Now I will read these lines. Held, since the construction of road is an infrastructure project, keeping in view the intent of the legislature, as evidence under section 41 HA of the specific relief act, that infrastructure projects should not be stayed High Court would have been well advised to hold its hands to stay the construction of the infrastructure project. This principle is now statutorily enshrined in Section 41HA of the Specific Relief Act 1963 as inserted by the Act of 2018. Hence, the principle underlying Section 41HA of the Specific Relief Act should be kept in view by varied courts while exercising jurisdiction under 226. Specific Relief Act, Section 41HA, applicability of principle even includes infrastructure laws. These are all infrastructure projects. Judicial review, interference, ordinance dispute, resolution mechanism, scope of interference, contractual matters, government tenders, roads, highways, construction projects, limited scope of judicial intervention, very narrow scope, judicial process, approach basis for judicial decisions, strict adherence to constitutional valid statutes, rules, and judicial precedents, inference of statutory intent from recently enacted legislation for guidance of the court. Sorry. Government contracts and tenders, remedies relief, public law remedies, general principles, cases where power of judicial review ought not to be exercised. Public auction tenders, rejection of bid for non-compliance with prescribed format, and bank as non-interference with review, inviting contracts. So therefore, my lord, this decision of the Supreme Court, it is a confirmation of Section 41HA. Now, I will just take your lordship to Specific Relief Act 41HA. I will just take the lordship to Specific Relief Act. My lord has got that, madam. Specific Relief Act.
No. Specific relief act. No. Specific relief act.
We'll come to it later also, my lord. No difficulty. We'll come to this in a minute. I will just send it across to my colleague there. It will be placed before the lordship in a few minutes.
Yes, no.
Just to mention to your lordships, 41 of Specific Relief Act gives those circumstances where injunction when refused. That is Section 41. It says an injunction cannot be granted. They give various provisions and we are dealing with only HA. HA says, if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facility related thereto, or services being the subject matter of such project. And in the end of this act, right at the last page, they have given the schedule. Where's the schedule? Ah, the schedule is there, my lord.
It's on page 88.
That is after the 43, 44 schedule. It gives like road transport, ports, shipyards, inland waterways, airports. So in the schedule, under serial number 1, bracket E is airport, 1E. So 41 HA says you cannot give injunction in infrastructure projects. Now, what are those infrastructure projects? They say category of projects and infrastructure in terms of 41 HA. We come under 1E airports. Therefore, my lord, 2 compliances have been violated. 1, the statute says you cannot grant injunction. Apart from the statute, the Supreme Court says you cannot grant injunction on the basis of this statute. Because if you keep granting injunction in these projects, like we have, my lord, in Delhi, my lord will be aware, we have a very good metro system in Delhi. One man from Kerala was in charge of all these things. Though he made one condition, I will take over this if nobody interferes. But by the time the law also changed. So what was the effect? The Delhi metro was completed in a record time. There was no stay, there was no problem. Any order passed was vacated. Well, initially, the Delhi metro was conceived in 1961. There was debate in parliament about Delhi metro. But it took off after 40 years. But it has done so well.
Sir,
I think so.
because of the rain,
My lord.
lot of sound, so it's not properly audible.
We can stop it for the moment, madam. We can stop it for the moment. No problem. I would suggest like this to your lordships. Since we have reached so far, if your lordship feels it proper, I can continue either.
At 2, my lord? At 2? We'll continue at 2. At 2.
Or 2, or if you because this matter may not be over today.
So then,
I can come there and argue so that we won't have this sound problem. Your lordship give me an early date, I will come and do it. So far, we have done the main thing. Now only law I have to come and explain. Which date your lordship gives, I will come.
when is coming?
Can we come on
No, he.
12th, my lord? 12th of this month?
12.
12th. I will come.
Says 12, propose for 12.
Yeah.
Give me a moment, my lord. Okay. Just a minute.
You'll sign them.
12, okay.
I will come. I'm very grateful. I'm very grateful for the time given because this is actually a very confusing case. So that's why, and I will make a proper written submission with all the documents together.
It's
So
fine.
that your lordship need not go and travel here and there.
Right.
I will undertake that responsibility.
Okay.
I'm very grateful to your lordships for the kind indulgence in this matter.
Okay. So 12,
12.
okay. So then we'll say. On the, okay, so their presence may be recorded, huh? Mr. Balgopal, Lanet, Advocate General, State of Nagaland, for the petitioner, and Mr. A.G. Mohammed. And Mr. People. Oh,
I'm in one and he's in two, madam.
okay, for the one and Mr. P.V. Paul for respondent number one. Present. And then the Advocate General, assisted by your good name, please.
Miss, that is Vitso Rio.
Okay.
He's there in the court. Vitso Rio
Mr. Rio.
and Nitya Nambiar,
And-
Miss Nitya Nambiar.
Hmm.
And I think my additional AG is also there. Sukre is also
Yes.
there.
Okay.
There, her presence also may be recorded.
Yeah, okay. Stop.
Right.
On the. Hmm. On being agreed upon by the parties, list is met again on 12. For admission hearing. Okay.
As part heard, madam. As-
Part heard. Your lordship has heard it.
Posing on 12,
Yes. Yes, we'll continue the arguments.
I have not seen the latest notification. Supposed to be, but then I have not seen the notification. If I remain there, it automatically it
Very
will
well,
be a part hard.
Yes, sir.
But if that isn't done.
Very well, madam.
That is not there. Wherever your lordship is, we'll come.
On 12, huh?
Even if your lordship is not there, if it is part heard, we can still come and appear wherever your lordship is. That's no problem.
Let us see. Okay.
Keep it as part heard, my lord. And even there are other two matters, 17th and 18th is also our matter.
Yeah.
That also can be listed on the same date, if it's okay.
18 and 19 also.
Yes.
17 and 18, I think.
No, no,
Is it
17
17?
And it's three
no, no, 16 and 17 is similar. And 18 and
18 and 19. Same order, we can hear it after that. That's a small matter. It take only 10 minutes.
Lordship, even 23 also
Hmm?
connected. 18, 19
18.
and 23.
18 if,
18, 19 and 23.
18 if it's ready, then we can take up at afternoon.
Yes.
That's two, or on 12 only.
My AG will take up the matter, your lordship.
Okay.
Yes.
Keep it on the same date, man. I can appear in one more video conferencing in the Supreme Court.
Second.
Your lordship,
That's true.
In 18 and 19, a report was called for.
Hmm.
Whether the report is available.
I think the report is available, report.
Report in seal cover was called for.
On seal cover, it is available, I think.
In that event, if the report has come,
It's there.
your lordship may kindly allow us to have a copy of the report. It is not a confidential document.
It's in the seal
Yes.
cover. We have not yet opened, I think,
Yes.
seal cover.
Right, after that.
Then, so this will be taken up on
Same date, 12th.
12,
same day.
the same date.
Okay, so here,
Very grateful to your lordship.
okay, here the AG assisted by N and Mr. Jimomi for the respondent, huh?
In 23, I am for the petitioner, madam.
Also, you,
In
okay,
in
and,
23, I am for the petitioner.
and, just a minute, in 18, huh?
Your lordship. I think 23, I'm for your respondent number 2.
Just a minute, huh?
Yes.
No, this is,
Yeah, mentioning. Yeah, mentioning.
okay, 18, 19, same, huh? Well, so, in 23. So what I was thinking, 23 is criminal petition, yes. Okay, then in 23. 23, huh? 23 also 12, on 12.
Yes, sir.
Okay, Mr.
Very small matter.
Jimomi spoke for the petitioner, land counsel for the petitioner. And here in 23, the respondent is
The state and The complainant.
Okay, Ms. Sukri, huh?
Yes, for the respondent number two, I'm appealing. In item 23,
Item 23, you are for?
R2,
Okay,
yes,
Mr. Iralo for respondent number 2
yes.
and Santiago is in 18.
Yes, Lordship.
Okay,
And for the
in-
petitioner there.
Okay, in 18 Santiago, Santiago's numbers, names should also be reflected, huh? Twenty-three. 23 and 23 is which? No, just a minute,
The
huh?
state has also filed a petition for cancellation of bail in this matter.
23 is
23 in 18.
23 is related to 18 and 19, ma'am.
Yes, yes, okay. So in the 18 and 19, 18 and 19 is for the petitioner is Santiago, huh? And then Mr. Zimomi is for respondent, okay? And in 23, Mr. A. Zimomi is for the petitioner and the state is for the respondent, okay? It's paid for by the Lana Council for the party. This is matter again on 18, sorry, 12.
Okay.
Okay,
I'm aware.
okay. So,
Much obliged.
Okay, so we'll record that we have received the
Report, ma'am.
report in seal cover, huh? Okay, it's great. This
And
report-
also may I record my request that copies be given, which will be considered on the next day after opening.
report will be open, since it is in seal cover, it will be open on that day only,
Very well. Well, after that, we will aware of that.
after opening.
Very well. Your lordship may mention it.
Yes, okay.
Much obliged.
Much obliged.
Very well.
Obliged, Your Lord.
Carefully. It will be- Come on.
There have to be hearing news. আমি সে কি ও তোমার নিয়ে নেওয়ার জন্য তুই ভোটে বসে থাকবে নাকি? ঠিক আছে।
আবার ঢুকে গেল আমি স্টার্ট করলাম আমার শুরু বল আমি এগিয়ে যাই আবার টাকা তাই স্টার্ট করেছে শেয়ার টু করে না তাই যদি আমার কেস করা স্টার্ট করেছে ঠিক আছে তুই কি চলা বলা গে খবর করে গেলে আরো আমি তো লাগা স্টার্ট করে দিয়েছি রিস্টার্ট করেছে রিস্টার্ট করেছে प्लीज बेटर ना ये थोड़ा भाग ना होने रोज अभी কিছু করতে না একটা পজিশন নিতে একটু না লোকও বলে আমি করেছি তো
For admission, item number 24.
May I please, Lordship?
Yes.
Lordship, this matter is regarding an application under 42 of the CRPC. This Honorable Court has directed the PP to produce the CD today. On the last day also, he said he had it, but he didn't go through, so it's today for consideration of the interim. On the ground that the parties, they have come to an amicable settlement, and if this Honorable Court will be pleased to stay the proceedings since the parties have come to an amicable settlement. PP was supposed to produce the CD, was here this morning, but
So he was to produce scanned copy of the record.
yes.
So
I was informed that he got it last week also, but last week, since he didn't go through, he sought one more week time. It's fixed today. This morning also I saw him, but
what do we do?
Lordship, if Lordship, you can wait for a while for the PP.
Okay, after some time then.
Yes, Lordship.
Hmm.
Oh, Lordship. He's here, Lordship.
Okay. Yes. sir.
If Lordship pleases, if the PP has no objection, it's Honorable Court may kindly consider the interim prayers.
Interim
Petitioner
prayer.
and the accused.
No,
They are-
Let us see the, so what is your
The
instruction?
parties have jointly filed this
Lordship.
petition, Lordship. The complainant and the accused, they have jointly filed this application.
Lordship, may kindly come to the last page, Lordship. Page 31. The last page, Lordship. Yes. If I may, Lordship. Yes, please. Second paragraph, Lordship. Now self-aware, the accused, the prisoner accused, accused Bhajan Gupta, son of so and so, before expiry of 10 days, police remand as the accused has voluntarily accepted his guilt and his custody is no more required, Lordship. So if we go by this, Lordship, investigation is already completed, Lordship. The charge is submitted. Lordship, as far as this was on 17/5. Lordship. Now, what is the latest report? Whether the case has been submitted into charge sheet? Lordship, that I'm not aware, Lordship, since this is the case diary that I received. No, this is. But this was that back to. Just a minute. No, where? What is the offense? Law against the
Lordship, it's a
409.
409 420 cheating, Lordship.
409, 420, 334. FIR, though, it will be difficult, but then you just can you obtain instruction whether the case has been charge sheeted or not? Lordship. FIR, though, it will be difficult. If it has been submitted into charge sheet, let us see. But in the meantime, then
In the meantime,
you
it's
obtain
investigation
instruction.
of
We'll take up tomorrow, on Thursday. Just obtain instruction as to whether the case has been submitted into charge sheet or not. Lordship. Okay. On Thursday. So because if it is in the act, still under investigation, it will be difficult. We can't interfere with the investigation. Can't stay. It will be difficult. But and probably since it's been a long time, since
Lordship.
then, Probably the case has already been submitted into charge sheet, and let us see. And then otherwise the records are there.
Lordship.
Some records are there, some statement probably. Statement.
Statement is there. Statement
Okay.
is there.
Now let us see,
Everything has been
let us see,
under
that.
160
Let us
RCC.
present status of the case.
Lordship.
Okay.
Lordship.
But then FIR as such, it will be difficult because the under 482 also, if the case is pending before the court, okay, but then if FIR, if it is still under investigation, it will be difficult. We'll have to wait for, see the progress of the investigation. What time it will take, we do not know. Okay, so as prayed for by the Learned Counsel for the party, list this matter again on Thursday, on which date the Learned PP shall obtain instruction as to whether the case has been submitted into charge sheet. Sorry. And the obtain instruction regarding the latest status of the investigation of the case. Okay.
Obliged, my lord.
For admission, item number 25.
May I please, your lordship.
Yes.
Lordship, this instant criminal petition has been filed, been agreed by the learned special judge NTPS Kohima lordship. Where for interim bail was granted to the respondent accused.
8-4.
8/4/2024 lordship.
Interim granted.
Interim granted, and thereafter extension of 75 was granted to the
Oh,
lordship.
bail.
Lordship, here, the state has preferred the instant criminal petition under 482, under 439-2.
39-2.
439-2.
For cancellation of bail.
Lordship, for cancellation of bail, lordship. And the last occasion, my learned friend, he
So you
appeared.
were granted temporary bail.
Lordship.
For how many days?
First for 2 months.
Okay, then thereafter,
Extended by another 75 days.
whether the 75 days expired?
Yes, my lord.
When?
20 August,
21 August.
21 August, it
21.
expired, and thereafter what happened?
Thereafter, I filed a petition for extension and regularization.
Extension granted?
Yeah, no, it's fixed on 11.
You have to surrender
Lordship.
immediately on expiry of the bail granted, temporary bail granted to you. It's your duty to surrender before surrender and then surrender before the jail authority. It was
Lordship,
there.
Lordship, in fact, on the last occasion, I have submitted the order passed by the special judge NTPS Act, Kohima, Lordship. I think that must be
Now,
on
you
the
see, you-
court, Lordship.
Ask for regular bail, surrender.
Lordship. And unfortunately, no effective order was passed while passing this order, Lordship.
Okay, the first was granted on 8-4.
8/4/2024, and thereafter.
This is on humanitarian ground.
Lordship. And my lord is also well aware, and my lord may appreciate that this is an NTPS case, Lordship.
So the last extended, when it expired?
It expired on 21st August.
21st August.
Lordship.
Where is the order? The last extended order? Have you annexed? At the time of granting bail to you, whether the case was submitted into charge sheet or it was still under investigation?
It was still under investigation, my lord.
So whether now the investigation complete?
No, Lordship.
Not yet. Okay, just let us see the first,
lord,
the FIR, just a minute. Sir. The allegation against the accused. It's a suo motu.
Lordships. Lordship, the extension, the
Yes.
extension order, which is at page 16, Lordship,
16.
annexure 2, Lordship. This is the last extension that was granted to the accused. Now, Lordship, as far as this case is concerned, Lordship, now accused, respondent, the charge sheet has been filed, Lordship.
Okay,
And now, as far as, if we go by the charge sheet, Lordship, FSL report is also there, and it
there
turned
is a
out that.
prima facie case, there is a prima facie there is a case against the
Lordship,
accused.
Lordship. And moreover, Lordship, there are some co-accused
Okay,
who are yet to be arrested, Lordship. And they are also the supplier of the drugs, Lordship. So
this is
they
filed
are,
by the state, okay.
Lordship. Now, here, the accused respondent, who is the kingpin, Lordship. Now, some of the co-accused that has been, as far as the statement, they are likely to be arrested, Lordship. But however,
Not yet arrested.
not yet arrested.
You
Lordship.
said that charge sheet already filed.
Charge sheet has been filed with regard to the respondent accused, the present respondent accused. But however, the co-accused, the supplier, those who have supplied the drugs, they have not been arrested.
How many persons have been arrested till now? 4. 4. Okay, few more are to be arrested.
Lordship.
And against them, what the charge sheet says?
Lordship, since they have not been arrested so far, as far as the co-accused is concerned.
What the finding says, finding of the IO.
As far as the funding of the IO says that they are yet to be arrested.
Yet
They
to
are
be
under
arrested.
surveillance, Lordship.
No, after you said that in the last extension was for 75 days,
Lordship,
which expired on
21st of August.
21st of August. Thereafter, he has not been arrested.
He has not been arrested, Lord.
What prevent the police to arrest him again? Because the bail extension expired.
Lordship.
What prevent the police to re-arrest him?
Lordship, as I have stated in my
Because there, the bail, you said that it expired. Now he's supposed to be inside.
Lordship. He is supposed to be inside,
Yes.
Lordship.
Now what
Now-
prevent the police to arrest him and put him in the jail again? Anyone objected?
In fact, Lordship,
Ah.
when this matter was moved before the lower court below, Lordship,
Ah.
after the matter was heard, Lordship, Lordship, most probably the accused must have absconded, Lordship. Because of that, Lordship, could not arrest the accused, Lordship. Now the accused is on run. Accused is on run, Lordship. And Lordship,
You see, the court considered and granted bail on humanitarian ground. It's duty on your part again to surrender on expiry of this, the bail, extended bail. Sincerely surrender before the court or to the jail as per the direction of the court. Unless it is extended further. and then apply regular bail. That is normal, what you should be doing.
Lordship, may kindly come to page 40, Lordship. Page 40 of my petition, Lordship.
What is this page 40?
The last paragraph, Lordship.
Yes, what is that?
If I'm allowed to read, Lordship.
Yes, please.
Last paragraph.
Mm.
Further, as Lordship has got,
Yeah.
further, it is to be noted that the present accused, Matthew S.H. was previously involved in a case connected to the Nagaland Narcotics Cell, PS case number 001/2020 under section 21C and 60 of the NDPS Act, special case number 001/20. He is currently absconding, and an absconding charge sheet was filed against him under CS number 001/2021 dated 17/1/2021. Lordship. So now, Lordship, he is the prison.
Subsequently thereafter, he was arrested in connection with this present case.
Lordship.
Should also have been shown arrested in this case also,
Lordship.
if the police required him to be arrested, and then if the police wanted to take his statement.
So at this present stage, Lordship, my humble submission before the Lordship is this bill, the bail petition, we are praying for the cancellation of the interim.
Whether for the cancellation or because. Okay, so this is during the pendency.
Lordship, now the matter has been fixed on 11/9/2024, Lordship, before the trial court below, Lordship. 11/9/2024, Lordship.
Fixed for what?
Lordship, if you go by this, it states that list the matter for hearing on the extension / regularization of the interim bail on 11/9/2024.
Where do we find that?
Lordship, in the order.
Order page?
Lordship, just now I give you.
Okay,
Lordship.
Loose paper. Okay, yeah. Anything to submit?
Yes, my lord,
Yes.
your honor. I was arrested on 16, my lord, my affidavit in opposition I filed this morning.
Okay, you have filed affidavit also?
Yes, my affidavit.
Saying what?
The BP. I want to press some.
It's not here.
Affidavit in opposition this morning, I think.
What we are saying,
My lord.
affidavit?
On 12th
What is,
of February, 2 persons were arrested for alleged recovery of contraband item from the possession. It is written in the FIR, my lord, in the FIR. Then after they were arrested, on the statement, my name was also mentioned. My name is Matthew. My name is also found mentioned in their statement when they were in the custody of the police. Thereafter, the police came and arrested me. And while I was in custody, the first petition that I've moved was on 28/3 March 2024 before the Honorable Court of Special Judge. There, the Honorable Special Judge was not pleased or considered to grant my bail on the 28th March 2024. Thereafter, that was my first bail petition that I moved before the Honorable Court in March after my arrest. Then thereafter, while I was in custody, unfortunately, it was learned through my villagers.
That is why a temporary bail was granted.
That time not granted in the first petition. And the first petition, which I moved in March, my bail was not considered. I've annexed that in my affidavit in opposition, page number 14, annex A.
No, just see, whatever may be, but then ultimately you were granted temporary bail because of the demise of your relative.
Yes, my lord.
Subsequently, it was extended on your request.
Yes, my lord.
Okay, then what?
Then subsequently it was extended because after my
75 days extended.
my lord, because I want to mention one more thing, because after my release from custody to go and meet my my mother's funeral, to be in my mother's funeral, thereafter I was called by the police to come to Kohima. I was called on the 12th. I was released from here until from the 10 of April. Then when I was in the village, within the 2 days, I was told by the IO to come to Kohima. So such in good faith, despite of my funeral being observed, I came to Kohima. Then they told me to come to PHQ. So I went to the PHQ. Thereafter, they told me to come to the North Police Station on the same day. Then having no one there in the PHQ, again I proceeded towards the North Police Station. I am obeying to the directions and directives of the investigating officer and the police team. Thereafter, then in the North Police Station, I was detained. I was served a copy of the detention order under PIT in DPS Act, my lord. Thereafter, I was immediately sent to Dimapur.
No, that you, after interim bail.
Yes, after interim bail, after 2 days, I was called to Kohima again.
Again rearrested.
Yes, again rearrested, and because a PIT in DPS order came against me. A PIT in DPS was proposed against me.
Another NDPS.
No. In the
Same.
same case, detention order.
Despite of the court granted you interim bail,
Yes,
you were rearrested
rearrested because of the PIT in DPS order.
because of the.
Prevention of illicit trafficking.
Okay.
Yeah, PIT in DPS, my lord. That's what-
Okay.
That order was proposed against me by the government, and I was arrested for the same order and put back in Central Jail Dimapur.
Okay.
Thereafter, my lord, that PIT in DPS, that order was revoked by the advisory report. Which I have also annexed there in my
Okay, that is not there.
okay,
It's there.
in my affidavit in opposition.
Okay, then
In my
what we'll do, I think there's some thereafter, subsequently, if he was rearrested.
Lordship, that also I have annexed in my petition, Lordship, with regard to the revocation of the detention order that was passed by the chief.
How many days you were there after rearrested?
Almost a month.
Almost a month.
Yes, my lord. Then after that,
And this was communicated or placed before the line trial court.
yes, my lord.
And thereafter only he was, your temporary bail was extended thereafter only.
Yes, my lord, exactly.
Okay.
So
But after considering all those only, it was extended.
after the expiry of 75 days,
Hmm.
I came before the honorable court on the 21st of this
Which court?
August.
Which court?
This is a special court,
Okay.
the concerned court. There, I filed a bail petition there before the honorable court, praying for extension or regularizing my interim bail. Then I surrendered myself. My signature is also found reflected in that. I, along with my
After expiry.
yes, on the same day, after expiry.
After expiry of the 75, extended 75 days.
Yes, my lord. I was before the special court. Then I filed a petition for regularizing my bail petition.
Okay, what happened then?
Then the honorable court, the special court, fixed the date for hearing on the 11th of September 2024. This month, September 2024. 11th of September, my lord.
So, it was extended up to September to September.
No, my lord, it's not
September
as my
11th?
PP is stated. It is not written here reflected, but however, it is fixed on 11 of.
No, 11, whether the temporary bail has been extended till 11/9/20.
It's not
No effective order has been passed.
Then
That we are agreed.
you are supposed to be inside.
Lordship, exactly.
Oh, I think probably there's found defective. You have to, I think.
Okay.
So this will place it on again on no, some order has to be passed. It is on 9th, 11th.
Yes, my lord,
9.
11. On the date they may extend, they may cancel the bail.
So
my lord.
can you correct, there is some defective today, correct it today and we'll take it up tomorrow.
Affidavit in opposition.
Yes,
Okay.
take it up
my lord,
tomorrow.
I humbly pray if it can be another date because tomorrow I have.
Another day, tomorrow or
Not-
Thursday then,
Okay, that.
Thursday.
That is okay.
Because
Lordship,
Wednesday is
now,
DB.
now the matter has been fixed on 11 of this.
That is
of this
why,
month, Lordship. So, Lordship, our main objective is to cancel the interim bail that was passed on 8/4/2024, as well as on the extension that was granted. And thereafter, on 21st, they have the lower court below has already passed an order where there is no effective order has been passed, Lordship. And because of that, we are unable to arrest the accused, Lordship. And
No, so
moreover, Lordship,
that is why I'm saying no effective order has been passed.
Lordship.
The extended temporary bail expired.
Lordship.
And according to me, nothing prevent the police to rearrest him. Who will ask?
Okay.
Because that expired and then court has not extended.
Lordship.
And the police wants the order from the court only.
Lordship.
So
Lordship,
that
since-
we are doing that duty we are doing, and then police has not acted upon. So that if you are waiting for that, then you will have to wait for Thursday. Otherwise, Wednesday. Tomorrow, is it not possible tomorrow?
Tomorrow, my lord, I'm pre-engaged.
Huh?
Now,
I'm pre-engaged, my lord.
Oh, yeah, okay, Thursday.
Thursday is okay, my lord.
Thursday. The next
Okay,
date
okay,
will be
ma'am.
Thursday only. No?
Or else,
So you correct it. If
okay,
then-
or else, my
okay.
lord,
Hmm.
if I'm allowed to mention, it is fixed on 11. 11, my bail may be considered or may be cancelled. So if we can wait that date, then that will be in the
So
interest of justice.
That-
On the 11th, the
that can
honorable
also
court,
be.
special court may cancel also. May,
Now, since they have filed
Lordship.
so
now
it will be the
filed
interest of justice.
application for cancellation because
Lordship.
according to
Before-
them, that the order should not have been extended.
Lordship.
The temporary bail, if it was granted for some reason, there was no further reason to extend the temporary
Lordship.
bail.
Lordship.
So then they want this order, whether. Let us see on Thursday, whatever, let us see. You have a good ground and let us see what ground we have. Okay, hard, Mr. Jimomi. Nana PP. Also hard, Mr.
Alam mo bang aw?
Nana counsel for the respondent accused, who submits that he has filed the counter affidavit today itself, which is not on record stuff. Please this matter again on Thursday, Thursday date is, okay, along with the counter affidavit filed by the respondent. Okay. Obliged.
Thank you.
From the supplementary cost list for admission, item number 40.
This is 25. What about 26? Okay, this is 40. Okay.
Yes, Your Lordship. By this revision petition, I'm challenging the impugned judgment in order of DB's court Kohima on the ground that the DB's does not have the jurisdiction to sit over the appeal of GB's court. On that ground, I'm moving this revision petition, Lordship. Because Lordship.
What is the status of the DB as per the
Yes.
local law?
Lordship, as per the rules for administration of justice and police in Nagaland 1937, the GBs and the DBs, they exercise the concurrent jurisdiction. They exercise the same
Okay.
jurisdiction.
So then the appeal lies against, appeal lies before,
Appeal lies only against
against. the
either
order of the-
deputy commissioner or
Okay.
assistant to
Assistant
deputy
to the deputy
commissioner.
commissioner.
Yes, as
Okay.
per rule
it
31 of
must-
the
So let us see,
Lordship.
impugn or the way.
Lordship, the
Just a
impugn,
minute, whether. Who appears for the other side? Okay, it was through a dusty service,
Yes, Lordship, it has been
but
completed.
no one appears.
No,
Lordship, I appear
Oh, you are
for the-
appearing.
I appear, yes.
Okay, appearing for the first time.
Yes. Lordship,
fine.
Lordship, I have no objection with the submission made by the petitioner
Yes.
because the customary court
Yes,
under
yes.
the rules, they do not have the
Hmm,
power to heard the matter.
yes,
However, Lordship, if my Lordship may kindly see, page 29 of the petition,
yes.
page 29, not page 29,
each.
and except for Lordship, the sole respondent, he has made an appeal to the Deputy Commissioner Kohima. And the Deputy Commissioner Kohima has endorsed the matter to the Revenue Office.
No, cannot.
No, Lordship, he can, the Revenue Officer can take up the matter. How he-
Endorse to whom?
To the Revenue Officer,
Huh?
Revenue Officer.
Revenue officer.
That is the Assistant to Deputy Commissioner.
Okay, assistant to the deputy.
Yes, yes.
Okay,
However, the Revenue Officer, instead of taking up the matter, he has endorsed back again to the head to policy, that is page 30.
oh, that cannot.
Yeah, they cannot, yes, they cannot take up.
Ah.
The right forum is the Revenue Officer, Lordship, that is the Assistant Commissioner.
It has to be taken up by the revenue officer.
Yes, by the
It
assistant.
goes,
But
the endorsement goes then.
that's why, my prayer is, since the Deputy Commissioner, he has rightly endorsed the matter to the
Right.
Revenue Officer,
It has to
let
send
the,
back
re-
to,
let the Revenue Officer take up the matter.
okay, we'll pass order then.
Yes, yes.
Pass order,
Yes,
set aside the impugn order then remanding back to revenue.
To the
officer
Revenue Officer, that is,
to decide-
page 30,
decide the appeal.
page 29, yes, to decide appeal, yes.
Your Lordship, however, I have one
Just a
more
minute,
submission. Yes.
let us see full, because I haven't seen it. So what is your submission?
Yes, the manner in which the respondent has approached the deputy commissioner
Hmm.
is through a letter. So it is not in a proper appeal form under Rule 31. So this honorable court deems it necessary that deems it fit to remand this back to assistant to deputy commissioner. Then a proper appeal may be filed by the other party, so that I'll be able to
Yes, Lordship.
find.
That can-
I have already written an application, Lordship, that is my page 29. And I may be allowed to approach the Revenue Officer, that is the Assistant to the
let us-
Commissioner, with a proper application.
Okay. Take this one, huh, the point, huh? Mr.
TK's, Your Lordship.
Okay, Land Counsel for the petition. I've also heard Mr. Yangarwati appearing on behalf of the sole respondent. This is a writ petition under Article 227 of the Constitution of India.
Lordship, this is a civil revision, not petition.
Who says writ petition? What is this then?
Civil revision.
It's a civil revision, Lordship.
You have written writ petition. You have not written civil revision. Have you seen?
Lordship, which page, Lordship, please?
Is this your petition?
From the copies I have received, it is civil revision, Lordship.
You've seen the petition.
Lordship, this is.
See this?
Lordship-
Yours written civil revision.
Yes, Lordship, although this is a civil
Yeah.
revision petition,
Hmm.
I'm invoking 227 also.
Okay, but
Yes.
see.
Lordship, the title is civil revision.
Yes.
Civil
Let's see, read that titles,
revision.
course title, read
Post title, petition under Article.
petition, no?
Yes, Lordship.
This is read.
Yes.
Since I'm invoking 227,
Okay, so this is, and again 32.
read with Rule 32 of the Rules for Administration of Justice and Police Law.
Okay. Where is the impugn order?
Impugn order, Lordship, What you will find in page 12, annexure 1.
Annexure 1,
Annexure 1, page 12, Lordship.
page,
12.
where is the type copy?
Type copy is in page 20, Lordship.
Okay, so this judgment, you have participated,
I have
Also.
participated, Lordship.
participated also.
Yes, Lordship.
You should have, you see, you have already participated. Also. You could have resisted.
Because your law, that is in the village court.
Or is- I'm asking you, where is the
Legal counsel was not.
impugn order?
sought.
Impugn order, I'm saying.
Yes,
This is village judgment of the village authority.
yes,
Where is
Lordship.
the impugn order? Which order you are impugning?
This impugn order. The DB's judgment. Page number 20.
This is in appeal. But you are aggrieved by which order of the deputy
I'm
commissioner?
aggrieved by the DB's order.
Where is the DB's order?
This
That's
this
I'm
is the
asking.
DB's order, Lordship. Translated copy is in page 20.
Page 20.
Yes.
No, DB's order has been challenged in appeal.
Yes. No, Lordship.
Okay, this is judgment in
GB
appeal.
Yes, yes. GB's order has the
No, where is the original
appeal
order?
of the GB was taken up by the DB's court.
DB's, okay.
Yes.
So
And
this,
I'm impugning
this
the
page
DB's
20
court
is the
judgment.
order of the DB's.
Yes, Lordship.
Okay, where is the original order then?
The GB's order.
No, earlier, GB's.
GB's order. Lordship will find this in page 27. Translated copy is in page 28.
Okay. Okay, by filing this civil revision, civil revision petition, the petitioner assailed the judgment dated 24/5,
Yes, Lord.
2024, passed by the DB's Kohima in poll case number 3, 2024. Stop. Okay, I'll shorten it and then elaborate it in the chamber.
Lordship.
Then I'll take up the order because some other matters are also there. So,
Lord,
in the case of the appellant,
my lordship, in the meantime, I will be allowed to file a proper appeal before the appropriate authority.
okay.
And also, lordship, I also submit that till the disposal of the petition, let the status quo be maintained. Status quo of the land.
Okay, just a minute. Okay, the case of the petitioner is that the initial complaint was lodged by whom?
By the respondent.
Okay, respondent herein.
Respondent in
The
this
case of
petition.
the petitioner is that the respondent herein lodged a complaint before the GB.
Before the GB's court.
GB's court for what?
This is annexure 2.
Annexure 2.
To adjudicate the matter between the petitioner and the respondent. Annexure 2, page 27.
Regarding what?
Regarding
dispute.
the land dispute. The instant land dispute. Page 25, Lordship.
Page 25 is a complaint
Yes.
letter.
This is the
This is someone only.
This is 25 is summon only, Lordship.
Where is the complaint?
Lordship, in the village court, we do not give.
Okay, regarding what? Regarding what then?
Lordship, the dispute is regarding an ancestral property of claiming an
Regarding
regarding
Landed property.
landed property, yes, ancestral property.
no, ancestral property for what? It is regarding ancestral property for what?
Your Lordship, in the present case,
Hmm.
the respondent is claiming the ancestral property of the petitioner.
Hmm.
The petitioner has been in peaceful possession all these years. Only in 2023, the respondent has come and claimed a portion of the ancestral property of the present petitioner.
Lordship, let the facts be decided by the trial court. We say just the dispute,
Re-
we'll just call
regarding
it
the
disputed land.
Regarding dispute about the ancestral property of the petitioner and the respondent. Stop there. And after consideration, this is only outline. The GB, where is the order passed by the GB?
The GB's order is in page
27.
3, page 27.
Page 20?
27.
27.
Okay. Okay. After hearing the parties and on consideration of the after hearing the parties, the GB decided this is numbered.
Case number 25, dated
Okay.
29/11/2023, page 28.
The earlier continuation of the previous sentence, which was registered as in GB number
Case number-
case
case
number
number
25.
25.
Case number 25. Oh,
Dated 29/11/2023.
there 25, stop.
29/11,
No, just a minute. Where was
page
the,
28.
where was the,
Lordship will find this translated copy in page 28.
there's 25, Stop, After hearing the parties. After hearing both the parties, the GB decided the case
In favor of the petitioner's family. Peratu.
and decided the case. We conclude that the land in dispute belongs to in favor of the respondent,
Petitioner.
Petition,
sorry, in favor of the petitioner.
petitioner's family.
Stop, Being aggrieved, I will elaborate that. Being aggrieved, who filed appeal?
The petition, the respondent,
Respondent.
the sole respondent.
Being aggrieved, the respondent filed appeal before. Where is the appeal?
The
First
deputy
application before the.
That is a
Where
deputy
is that?
commissioner, Lordship.
Where is that?
29,
Page
ratio 4.
20? 29, okay. The respondent filed appeal before the Deputy Commissioner Kohima for settlement of land. Just a minute. Appeal against the said decision of the GB before the Deputy Commissioner Kohima.
And the matter was endorsed to the revenue officer for disposal.
Stop, on 13/12/2023, stop. On it is submit, okay, on 18/12/2023, the matter was endorsed to
Revenue branch.
the revenue branch, revenue branch.
Yes, Lordship. That is the ESC revenue.
Okay.
Assistant.
That is the assistant to the
Assistant to the Deputy Commissioner.
assistant to the deputy commissioner for
Responsible.
disposal of the appeal stuff. However, thereafter, however, the assistant to the deputy commissioner,
Lordship, my Assistant Deputy Commissioner under bracket Revenue Officer.
revenue officer,
Under bracket Assistant Deputy Commissioner.
Okay.
That is under bracket.
the bracket, revenue officer. However, the revenue officer, Kohima, forwarded the matter to the head DB Kohima, Kohima Customary Court for settlement of the appeal staff. Para. The Land Council for the petitioner submits that the appeal from the GB court lies before the deputy commissioner or the assistant to the deputy commissioner. However, in the instant case, the revenue officer who is stroke assistant to the deputy commissioner who was endorsed by the deputy commissioner to settle the matter, to decide the matter, has re-endorsed the same, the appeal to the head DB for decision staff, a decision who has no power to decide the appeal filed before the deputy commissioner. That is a fact.
Yes, as
Okay.
per Rule 31 of the Rules for Administration.
Okay, as per the Rule 31 of the
Rules for Administration of Justice and Police.
rules of
Rules for
31 or 32?
Rule 31 of Rules for
Rules for
Administration.
Administration of Justice and Police in
Police in
Nagaland,
Nagaland,
1937. And read with section 115 of the Code of Civil Procedure. Stop. However, the DBs has taken up the matter hard and decided the appeal on decided and passed judgment and order on 24/5/2024. It is submitted that the DB has no appellate or no power to decide the appeal under Rule 31 of the Rules for Administration of Justice and Police in Nagaland, that is 37, and thus the DB has exceeded the jurisdiction not vested to it. Start. Hence, pray for. Hence, prays for setting aside and quashing of the impugn order. Stop. Impugn order and impugn order. Okay, stop. Mr. Yangavati, Land Council for the appearing on behalf of the sole respondent fairly submitted that the DB does not have the appeal power under Rule 31 of the Rules for Administration of Justice and Police in Nagaland, 1937, and has praised that the matter may be sent back to the review to the assistant to the deputy commissioner, stock revenue officer for decision of for decision of the appeal filed by the respondent. And in the meantime, what you said, this is only outline,
Are
huh?
we allowed to file a proper application
Ah.
and that there be
And
status quo?
since there is no proper application filed before the deputy commissioner, he may be allowed to, sorry, the respondent may be allowed to file proper appeal.
Yes, ma'am.
Before the
Appeal
deputy
memo.
commissioner. For proper adjudication of the appeal stuff. Hard board the land council for the parties, then I'll decide. Okay.
Lordship, status quo be maintained also. Status quo till disposal of the petition.
No, no, that I recorded
Yeah,
your
yeah.
submission.
Yes, ma'am.
So
Much
order-
obliged. Much obliged.
Obliged, Lordship.
For orders, item number 26.
26. Okay. Yes. Non appears. So what is this? Huh? It's contempt of 2012. This is 2012 case. What happened? Oh. No one appears. On behalf of the parties on call staff, huh? As per the order dated 5/12, as per the order dated okay. By an order dated 13/8/2024, the registry was directed to inform the parties. Staff, huh? The office note dated 30/8/2024 reflect that the parties was informed and correct consignment receipt confirmed that the consignment the correct consignment indicates that the delivery confirmed upon the petitioner number 1 and 2 on 27/8/2024. However, no one appears on behalf of the party. In view of the above, case 10 adjourned. This is matter again after 2 weeks. After 2 weeks. Not posting anything. No, this I think has become infructuous. No, it has become infructuous. Let us see, huh? Leave that. None appears on call, huh? Stop. As per the order dated 5/12/2012, the matter is to be listed after the disposal of the case pending before the Honorable Supreme Court and as per on the Supreme Court, huh? Stop. The office note dated 9/8/2024 reflect that the civil appeal number 3607 of 2016 pending before the Honorable Supreme Court has already been disposed of by order dated 23/7/2024. Stop. Huh? The order read as the order of the Honorable Supreme Court read as under, stop. Sorry, inverted comma. The civil appeal is disposed of as having become infructuous in terms of the sign order, stop. The contempt proceedings are dropped and the contempt notice is discharged, stop. As a result, comma, the pending interlocutory applications, including the application for intervention, comma, stand disposed of, stop. Para. In view of the above, this contempt petition has become infructuous. So accordingly, this contempt petition stands closed in terms of the order of the Honorable Supreme Court dated 23/7/2024. Okay.
For orders, item number 28.
Yes.
May I please, Your Lordship? Your Lordship, I'm appearing for respondent number 2. Your Lordship, I filed my Bagalat number this morning, Your Lordship. Your Lordship, may kindly give me 1 week time to file affidavit in reply.
Okay. You are Miss?
Miss Wanchano.
Okay, you are Miss? For the
Asalamualaikum.
petitioner
Yes, Lordship.
in the IA? Okay. Miss?
Asalamualaikum.
Okay. Then counsel for the applicant is present and Miss
Wanchano Hunjai.
who appears on behalf of the respondent. How many?
To Your Honor.
Hmm?
Respondent number 2.
You are for one.
I'm for the one.
Okay. Then Mr. Siva Pong, then counsel for the respondent number 1 is present. You are also present, right?
Yes.
Okay.
Since the respondent number 2 has appeared.
Okay.
So
And Miss her name, huh? Would appear on behalf of the respondent number 2 and prays for how much time?
1 week time, Your Honor.
1 week time to file
Affidavit in reply.
affidavit in reply. Affidavit in reply.
Position.
Opposition. The prayer is allowed. Please this matter after a week. Okay.
Pleasure.
Yes.
For hearing, item number 29.
My lord, I already did my part. It is for my learned friend to make his submissions.
Yes.
The last date, I already made my submissions.
Yes, yes. So, have you filed a list of dates or your
Those things are there, my lord.
your written submission in short will help me. Yeah, because it appears to be
Well, the matter,
voluminous, but then
well,
submission as you made is short.
My lord, it has become heavier only because of the fact that.
That is why.
No, only because of the fact that the original appellant died, substitution had to be made.
Okay.
And during this process, my lord, the file has become heavier. Otherwise, my lord, the issue is very simple, very short and precise. It is only because the original appellant died, his successors had to be brought on record.
Okay.
That is why, my lord, the file has become heavier.
Okay. So that were in that line also, but in small written.
Yes.
Yes.
Otherwise, the list of dates, as your lordship is suggesting, my lord, that is problem, that is already filed and it is available in the records, I am told.
Is it?
Yes. And probably it is there. I'm just doing a check, my lord. List of date was maybe. Not in the appeal memo, but separately it was provided.
Okay.
Otherwise, everything centers around that application, one application and the determination by the trial court. That is the thing. And that application your lordship has seen.
Okay, there is a recast memo of appeal also.
Yes, that's why it has become bulkier.
Okay. So there is two recast, 18 October 22. Sorry, final necessity, 20 April 21, and then this is 22. It has become bulky.
But for the convenience, my lord, on the other day, I just straightway took your lordship to the relevant page. It is because the memo of appeal have been recast on occasions. That's why it has become bulkier. But the sheet anchor of the case is at that application, which is at page 208, the application filed by the respondents.
On that, I took some notes. I have not stepped in yet. Probably I took some notes. Put down. See it there. No, probably the notes taken also not there. So one small list of dates chronologically. So that will help me for your junior. Okay, so your
lordship had taken notes also.
Yes, that is why it's not available.
Okay. Oh, all right. I'll just provide that. I'll just provide that through my junior.
Okay.
May it please the lordship. Lordship, that day through BC I started, but there was interruption, so I could not continue.
Just a minute.
Yes, your lordship.
Your case in one paragraph would be?
My case in one paragraph is this, my lord. Page 208 is the application filed by them. They asked for rejection of my plaint under Order 7, Rule 11D.
Okay, so it was under
Rule 11D.
But
Trial court passes the order under Order 7, Rule 11A. This is my case in one sentence.
Yes, okay, that's fine.
And the second case is that, my lord, second part of the respondent say that my suit is barred under Assam Land and Revenue Regulation.
It is not.
Under what provision of regulation it is barred, that was not spelled out in the petition. Trial court gives a finding that it is barred under Assam Land and Revenue Regulation. But under what rule and for what reason, that is not there.
Okay.
This is my case.
Okay. Yeah.
Your lordship, I beg to take your lordship, that order, impugn order, judgment and order that passed by, it is page 251.
Page
251.
251.
251.
So until and unless we go through a whole judgment, your lordship.
Right.
Should I,
Yes.
page 251 is the, and actually prior to that, your lordship, that the case, the civil suit was filed by this Atikur Raja Khan, and opposite party was Jame Masjid and others
It
in the
was,
suit.
it was filed
It is my
by
petition,
Atikur Raja Khan.
Atikur Raja Khan. So now he substituted by his son, Salikur. So this is the order, your lordship.
It
250.
was filed by Jama Masjid.
Jame Masjid, we filed that CMC 2510. As my learned colleague has pointed out that
So
it was filed
the
under,
This is impugn order only.
yes, impugn order.
That suit number 1
Yes,
of 2010 filed by Jama Masjid,
Jama Masjid.
represented
No,
by,
no, your lordship.
this is not the impugn order.
This is the impugn order. Plaintiff has filed the suit. We are the respondent. Jama Masjid is the respondent. Plaintiff is Atikur Raja Khan and now Salikur Raja Khan.
No. This
Impugn judgment. That
impugn
case,
judgment is filed by
it was passed by learned
no,
civil
it was filed by
filed by Atikur Raja.
Probably, my lord, your lordship is looking at page 215.
yes.
250 is the page of the cause title of the civil miscellaneous case, which
Yes.
Jame Masjid committee had filed.
Again, in the then 251 is it's all the same.
Same.
Continuation.
Continuation of 250. The CMC application was filed by the Jame Masjid committee.
Suit
Now,
was
this is the impugn order.
Yes,
Yes.
page 251 is the impugn order.
impugn order.
Okay, so impugn order, this impugn order was between Jama Masjid
And Atikur Raja.
and
Atikur Raja Khan,
Atikur Raja Khan.
who is the predecessor in interest of myself. He died and thereafter, my lord, I was substituted. Atikur Raja Khan died and there in his place, my lord, the present appellant was substituted.
Okay, the appeal is filed by
Atikur Raja originally.
Originally Atikur Raja, now represented by his son Salikur Raja.
you represent the Jama
Jama
Masjid.
Masjid, Jama Masjid. And there are 1 to 12 I am representing, your lordship,
Yes.
and 13 to
11. 1 to 11.
1 to 11. 1 to 12 actually it was originally.
Yes.
Now 1 to 11. That one person died, Halim Khan died.
So Jama Masjid filed application under order 7, rule 11A,
11D.
D.
11D.
Yes.
But then he decided under 11A.
Yes.
It is, so that is why whole judgment is to be go through.
Okay. Just a minute.
This 251, this whole judgment has to be done through your lordship.
Just let us confirm just once
Yes, your lordship.
the plaint.
Plaint. Plaint is at your lordship. Plaint is 28 probably.
Plaint is at page
28. 28.
It is at 28.
There are 2, 3.
My lord, plaint may not be necessary for the purpose of this.
No,
Number.
no, your lordship. It is necessary, your lordship.
Just a minute. The application is under.
For that, your lordship will have to see the application they had filed. That is at page 208.
Not 28.
No, 28 is the plaint filed by.
Your lordship.
28.
Let me finish or you.
No,
you
just a minute.
finish and I'll start.
Just a minute.
I'll start. I may see.
Just a minute, one by one. So I'll give this judgment this judgment, impugned judgment is passed in
CMC application.
CMC number 25.
Yes.
25.
Where is CMC number 25?
That is 208, page 208.
CMC 25.
Yes, 208.
Where is 208? Okay,
208.
let us see that one once. This is, let us confirm that this is under 11D only.
Yes.
11D. Okay, now you can continue.
No, 251, Your Lordship. The judgment is to be read out wholly, Your Lordship.
Okay.
No, should I read?
Okay.
The applicants and defendants filed this application under Order 7 Rule 11A, read with Section 151 of the Code of Civil Procedure 1908 for rejection of the plaint entitled suit number 1/10.
Okay, just a minute, huh? So this we have read just now, 11A. Now we have just seen that it's 11D.
11D. Our petition is 11D.
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 But then you agree that this is decision is under 11A.
It cannot be said if your Lordship kindly go
You
through.
see the starting, defendant filed this application.
This might be a typography mistake or any other mistake. I do not know. Because we have filed under 11D.
No, just a minute.
I cannot say that on Your Lordship, how it has come under 11A.
The reading will do, but then just. But then no review was filed.
A review.
Okay,
Here in
for
this
correction of this typographical error, if at any.
Prior to that, Your Lordship, the crux of the case is that this Atikur Raja Khan, he filed initially one civil suit number 1/2009 against the same party, praying for his declaration of right and all this. Then that suit was disposed of, dismissed under Order 7 Rule 11D. After that, he filed a review petition, review application, that was also dismissed. So instead of assailing the same, instead of filing an appeal, he again suppressing the factum, he again filed this civil suit number 1/10 on the same matter in issue, which is barbai res judicata under Section 11 of CPC.
Okay, anyway, let us read now.
Yes. The applicant defendants filed this application under Order 7 Rule 11A, read with Section 151 of the Code of Civil Procedure 1908 for rejection of the plaint entitled suit number 1/10. The brief of the application arising out of the said title suit number 1/10 is that the respondent plaintiff filed the said title suit for declaration of right and title. This may be noted, Your Lordship. A declaration of right and title over a plot of land within the north side of Dag number 203 of the block number 6 of Dimapur town, relying on a permit dated 20/2/1963, purportedly issued by Assistant Commissioner Dimapur, wherein it mentioned of Dimapur Bazaar. The respondent plaintiff averred the said permit is a grant under the Assam Assessment of Revenue-Free Wasteland Grant Act 1948 and paying the Dow house tax. Thereby the applicant prays for rejection of the plaint on non-disclosure of cause of action, as the respondent plaintiff has neither pleaded the material facts that the suit land in the instant case is pertaining to the purported grant under the Assam Assessment of Revenue-Free Wasteland Grant Act 1948, nor essential component to constitute the facts to prove the case, such as entry of an estate in the Deputy Commissioner's registers of Revenue-Free Estate as a separate grant. Number 2, the issue of an assessment roll, Jamabandi. Number 3, the record of the rates assessed on such estate. Finally, the validity of a settlement granted by the competent authority and the formation entries in the record of rights in consequence of such settlement cannot be challenged before the civil court under Section 154(1)(a) and C of the Regulation 1886. Now 154, Your Lordship, I am coming. What is 154? Considering the submission of the respondent plaintiff to reject the application on the ground under the rules of administration of justice and rule police in Nagaland 1937, there is no scope of Order 7, Rule 11D of Code of Civil Procedure 1908, as it envisages framing of issues of facts and law and to decide the case. It is true that the Code of Civil Procedure 1908 is applicable in the spirit only, not in letters, in the state of Nagaland, wherein it means where the procedures are lacking in the rules of administration of justice and police in Nagaland 1937, the Code of Civil Procedure 1908 applies as a guide to resolve or adjudicate the disputes. All the state procedures may not be enforced. Therefore, rejection of application on the ground of application of the Code of Civil Procedure 1908 cannot be sustained or overlooked, as it is a public policy to avoid unnecessary litigation. Besides, the applicant's defendant's counsel has rightly pointed out the trial court can exercise its power under Order 7, Rule 11 at any stage of the suit before registering the plaint or after issuing of summons to the defendant at any time before the conclusion of the trial, and for the said purpose, the averments in the plaint are germane, and the pleas taken by the defendant in the written statement would be wholly irrelevant at the stage was relied on the Honorable Supreme Court of India decision held in Salimbai and others versus State of Maharashtra and others, 2003, 1 SCC 557. Therefore, the respondent plaintiff contention has no merit and the instant application is sustained. Secondly, the respondent plaintiff contention of one of the pro forma defendants had appeared despite of summons served and objected to accept the prayer of the applicant defendants in their absence cannot be sustained. The status of the pro forma defendant is to assist the court during trial, and therefore, when the plaint can be rejected at its initial stage, the pro forma defendant's appearance should not hinder to dispose the application. Thirdly, the respondent plaintiff further raised the present applicant's defendants has no locus standi to file the present application as mutawali only, as the locus standi under Waqf Act 1995. The applicant's defendants are impleaded as defendants in the said title suit by the respondent plaintiff, not the mutawalis under the Waqf Act 1995. So, when the respondent plaintiff has not impleaded the necessary party as per the law, the applicant's defendant's name has to strike out, and at the same time, the plaintiff's plaint cannot keep alive without impleadment of necessary party. If there is any disclosure of cause of action in the title suit, number 1/10, necessary parties can be impleaded if the petition cannot survive as per the CPC. Fourthly, the applicant's defendants have the title documents issued by the competent authority covered by Patta number 157, DAG number 203/215 of block number 6 of Dimapur town, Nagaland, whereas the respondent plaintiff have permit dated 20/2/1963 purportedly issued by Assistant Commissioner Dimapur, wherein it mentioned of Dimapur Bazaar without concrete location, and the said permit is extracted here in for easy reference. Government of Nagaland, Office of the Assistant Commissioner Dimapur, permit to Sri Adam Raja Taylor, Dimapur town. You are hereby permitted to hold and enjoy with your tailoring business in the occupied plot of land at Dimapur Bazaar, measuring 5 years by 15 years, only in existing structure which he can improve. This permit shall be treated as cancelled in the event of desertion in favor of unauthorized person, such and such. Memo number such and such, dated Dimapur, 28th February 1963. So this is the permit, Your Lordship. It was issued way back in 1963. Now further, it is annexed that the respondent plaintiff has paid Dow tax on 16/2/09 for the period 1971 to 2009 at office of the Moujadar, Mouja number 1, Dimapur, Nagaland, for the purported sweet land in question amounting to rupees 195 only, that is 5 years into 39 years. Plaintiff Annexure 4 series, page 27 to 47. After the additional Deputy Commissioner Dimapur, Nagaland had ordered all the mutation partition granted in Dag number 203 was ordered, cancelled and corrected the mutation under Dag number 215 and record changed into the name of Jame Masjid by the order number such and such dated 19/12/91. Plaintiff Annexure 14 and issued Jamabandi Patta number 157/598, Dag number 203, Moja number 1, block number 6 to the Jame Masjid committee. Despite of all this, the concerned Moujadar has collected dhow tax from the respondent plaintiff. After this, the respondent plaintiff applied for survey and demarcation of the said scheduled land cover dated 9/2/10, Plaintiff Annexure 18, reflect highly questionable function of such authority, as it is not only to collect revenues by hook or crook, but it is their bounden duty to assist the public to mobilize legal revenues which are in district revenue record only. Therefore, on the face of the record, there is no title document of the respondent plaintiff. In the present suit, there can be no title dispute within the cadastral area in Dimapur on the above facts, except where there is an express provision of law to which no such facts pleaded in the instant plaint. The civil court cannot interfere into the competence of revenue authorities in allotment of land unless there is a prima facie commission or omission of curtailing a person's right in view of the above provisions. Whatever title it may be issued without entry in revenue authority record, it must be treated as illegal. It is unfortunate to see that a permit purported to be a grant under the Assam Assessment of Revenue Free Wasteland Grant Act 1948 for more than 72 years has no record in the revenue authorities. Therefore, agitating after allotment to others cannot sustain, as it is a matter of record of rights, not possession only. Besides, it reveals that the respondent plaintiff, here it is the main, the respondent plaintiff had filed CS 1/09 on the same facts and issues and rejected by the learned trial court and thereby assailed for review by review case number 1/10 but failed. On the above fact, this court has no jurisdiction to entertain the suit, as rightly pointed out by the applicant defendants learned counsel. Status quo passed by this court.
Just a minute here in the above line.
Yes.
Above provisions, which above provision?
It reveals that the respondent plaintiff had filed CS 0109 on the same facts and issues and rejected by the learned trial court and thereby 01/09.
Where do we find? Oh, no.
Your lordship will find at page 104.
Okay, which one? The
CS 1/09.
no, 1/09.
Yes.
Beside it reveals that the plaintiff, no, about the civil court cannot interfere into the competence of the revenue authority in allotment of land unless there is a prima facie commission or omission of curtailing a person's right in view of the above provision. In view of the above provision, which provision this mentioned?
Just a minute. This Nagaland land revenue regulation.
Okay.
Yeah, Assam land revenue regulation or this
District revenue
land settlement. Land settlement.
Where?
No, it is not there, your lordship. It is not there.
Land settlement.
Now here you'll.
Here, okay.
CS 1/09.
CS one of the zero. Beside it reveals that the respondent plaintiff had filed CS 1/09 on the same fact. Okay, yes.
So on the same facts
Rebuke
and issues and rejected by the learned trial court and thereby assailed for review. Then against this order, they filed on review petition. Review also rejected. Then suppressing the facts, your lordship.
No, my lord, I'm sorry to say, there is no suppression in the plaint itself, it is mentioned. That is a wrong statement.
I am coming to that. I am coming to that.
Just
So
let us
No,
just
no,
read. Let us just read. Without addition. Okay.
109 on the same facts and issue and rejected by the learned trial court and thereby assailed for review by review case number but failed. On the above fact, this court has no jurisdiction to entertain the suit as rightly pointed out by the applicant learned counsel. Status quo passed by this court is hereby vacated. All CMCs pending disposal in connection with the case treated dismissed as it becomes infructuous. Application allowed, parties shall bear their cost. Now, here your lordship. And 255, page 255 is, this is in view of CMC 2510, in connection with this case, disposal this suit has become infructuous and dismissed accordingly, parties shall bear. Now, I beg to take your lordship.
In view of this, CMC 25. In view of the CMC 25.
Oblique 10.
This is.
The next order is passed in the suit.
Next order is passed in the suit. Title suit 1/10.
Okay.
Now, your lordship, I beg to take your lordship, page 104. First. Page 104.
Just a minute.
Civil suit 01/20,
Just a minute.
09. Now parties.
Just a minute.
Yes, your lordship.
Where was the plaint page? Plaint was at page?
This is 10209, 1/209. Otherwise, they are this 1/10 is 28.
No, this. 209, 25 of 10. Just a minute.
25
No,
of
no.
10 is at page 208.
This is
208.
208. 25 of 10 was initially numbered as 7 of 2010,
Yes, yes.
but it
Yes,
was
sir.
renumbered as 25.
25.
Okay.
Initially numbered as 7 of 2010, but later it was renumbered as 25 of 2010. Page 208 is the application.
Hmm. Okay, then.
I beg to take your lordship first. CS 1/2009.
Page
104.
10.
4.
Civil suit.
Civil suit. Artist Sri Atikur Raja Khan and son of late Haji Adam Raja Khan.
Yes.
Versus MD Hussain Khan, number 1. Number 2, the Jama Masjid Committee. Jame
So
Masjid.
this is filed by the.
Atikur Raja, same appellant. Appellant herein.
Filed by the appellant.
Appellant.
Okay.
Now, I beg to take your lordship to page 105.
Yes.
And in the matter of 105, a suit for declaration and confirmation of bona fide legal rights, title, and interest of the plaintiff in regard to scheduled plot of land and properties. And in the matter of prayer for restraining the defendants by issuing permanent injunction from illegal disposition, eviction, and interference in respect of bona fide enjoyment of rights, title, and interest who are on the scheduled plot of land premises, and in the matter of prayer to allow the plaintiff to deposit the monthly contribution concerned before the honorable court, if any, to be paid to any or both the defendants under the relevant provisions of law or otherwise. Now here I will make it clear, your lordship, that defendant, plaintiff herein, he was a tenant of Masjid committee. It is a Masjid property. It is all the Muslims' property, your lordship. He was.
My lord, again, I am sorry for interruption, my lord. These submissions are beyond the pleading.
No.
He has not filed any WS in this.
No, your lordship.
He has not filed any WS in this.
Let me finish. Let
him confine. Confine to the application he filed.
No, your lordship, I should.
Or let him locate his submission from the records.
No.
Lord, these
I'm
cannot be allowed.
This is record, your lordship.
Let him submit.
If he has filed a written statement saying that I am a tenant, let him show it from record.
Your lordship.
Otherwise, these statements.
No, your lordship. No, your lordship. These are the records from their record. It is this
from my
page. Your lordship, please.
I am telling to the court.
No, please. Let me finish.
Let him finish.
Let me finish. Or you are go for on my behalf. You are go your case.
I don't take your brief.
Then-
I'm good enough with my brief. Why should I?
Then let me finish. Let me finish. Nothing to be.
Show something from the record.
No. I'll satisfy the court.
Okay, please. Okay.
Now, your lordship. I beg to take your lordship. Page 111.
No, by reading this, what do you want to show? This prayer to allow plaintiff to deposit monthly contribution concern before the honorable court says.
If any to be, I am coming to later on.
Okay.
I am coming to later on. I beg to take your lordship then page 111.
Yes.
Schedule, plot of land and premises. Your lordship, it is situated on the west side at MP Road, Dimapur town, and the plot is measuring 5 years into 15 years, 15 feet into 45 feet, and standing thereon. Permanent structure meant for residential cum commercial activities, including facilities of natural amenity, and wherein enjoined with the electric facilities. This is his schedule. Your lordship, there is no boundary, which is on the north, which is on the south, which is on the east, which is on the west. There is no such schedule is given herein. Only he is claiming basing upon that purported that permit, which is said to be issued way back in 1963. And presently, the land is settled in favor of Jama Masjid, and they are the owner of the land, having valid patta. Now, your lordship, page 111, your lordship.
Yes.
The plaintiff therefore pray for a declaration and confirmation of continuous nature, bona fide legal rights, title of the plaintiffs, joint family in regard to scheduled plot of land and properties against the defendant number 1 and 2. That he is asking for declaration of bona fide rights, continuous nature. I do not understand what is that. To restrain both the defendants or anyone otherwise from their individual and common ends from forcible collection of voluntary monthly collection and disposition, and from illegal interference with the continuous lawful possession and enjoyment of rights, titles and interest of plaintiffs, joint family related with scheduled plot of land and property by issuing permanent injunction in due course of law, and in the meantime, kindly issue the interim injunction against the defendants. I do not know. Anyway, it is his prayer. Now see, your lordship, and kindly to allow the plaintiff to deposit the monthly contribution in favor of the Jame Masjid Hajipar, Dimapur, if any, to be paid as duty bound under the relevant provision of law or otherwise in accordance with the order of the Honorable Court. Now, contribution, monthly contribution, I am coming to that, your lordship. I am coming to that. To pass any other order or orders or reliefs in favor of the plaintiff family against the defendants as your honors deem fit and just for the hands of justice. So this is his prayer, your lordship. This is his prayer, and this is declaration of right, whatever. So any other relief, because Honorable Court is having power to mold the relief also. So here it is now I beg to take your lordship. It is a civil suit, your lordship.
Yes.
Now, page 1110.
110.
110. Para 9. Because this is for compilation of another civil suit. Para 9, your lordship, the cause of action.
Okay.
That the cause of action arose accordingly against the defendants number 1 and 2, and out of extreme unbecoming behavior and threat from the ends of the defendants number 2 on 2209 for forcible dispossession of the plaintiff from the scheduled plot of land and properties and related to permanent nature bona fide business. I do not know. This is the cause of action. Now, your lordship, I beg to take your lordship page 28. But it is also not page 28. Plaint.
No, so this, just a minute.
Now it is readable on
This-
what I.
This is civil suit 01.
01 of 2010.
So not the,
That was civil suit 01/2009. And this is civil suit number 1/2010.
the present, this judgment was of 2010.
2010.
So this you are showing us 2009.
Earlier I showed 2009. Now I have come to 2010.
No, this 2009 is whether this 2009.
Yeah.
Earlier the judgment we have read of 2010 only.
10 only. 2009 judgment is, I will come later on if requires to save the time. Now
What
I
happened to this 2009 one?
I beg to place before this honorable court that the same person, the same parties,
Okay, so.
while
so that-
2009 was dismissed, then he went for a review 1/2010. That was dismissed. Then he has come on the same matter in issue, this 1/2010.
Okay, so this is only to show that
Yes,
the appellant has come
yes.
on the same ground.
On the same
On the-
ground,
on
they
the same
filed.
dis-
They filed.
on the same
And
matter.
court has also taken that plea while dismissing.
Okay.
Now, your lordship, my
Page
copy is also page 28.
28.
What are you?
Yes. it is.
28.
Hmm.
Now, title suit 1/2010.
Same.
It is readable, na, your lordship? Page 28, your lordship.
Yes.
In the matter of
Hmm.
Sri Atikur Raja Khan,
Yes.
he is the plaintiff. The same plaintiff in 109. Then defendant. Number one, the Jame Masjid Committee.
Yes.
Then number two, number three, all these other defendants. That Muhammad Halim Khan, then Sirajuddin Chowdhury, then Abdullah Had, Jainal Abdin Talukdar, Aidur Rahman, Mohsin Khan. They are the member of Hajipar, that Masjid Committee. They are being made as party. But Jame Masjid is the main party. So here, your lordship, 1 to 12 are the defendants, Jame Masjid Committee and its members.
Yes.
Now I beg to take your lordship to page
So
29.
according to you, this is
The party,
same parties.
same party.
In the same parties.
Yes.
So here it's only two respondent.
Earlier, 19, there are two respondents. Jame Masjid Committee is a respondent. And here, Jame Masjid
Committee.
Jame Masjid Committee is a respondent, and their members have been made as defendants. Jame Masjid is a defendant, number one, and the member of the committee separately have been made as defendants.
Okay.
But main defendants is Jame Masjid Committee. Now here is from 13 to 20, there are pro forma defendants.
Yes.
Who are not pro forma respondents in this appeal. Now, I beg to take your lordship, and in the pro forma defendants, then and in the matter of title suit value 25 lakhs and ad valorem court fees of rupees 11,000, rupees 1,000 as ad valorem court fee for the reliefs paid, I do not know, rupees 5 as process fee in the form of court fee. Anyway, and in the matter of, this is declaration and confirmation of established and absolute lawful occupation rights, titles and interests. The same relief, it was sought in civil suit number 1/09. Parties are same. Then after the dismissal of the first suit, he has come with the second suit. Their prayer is also same. Declaration and confirmation of established and absolute lawful right, occupation rights, title and interest. Now, your lordship, my humble submission before this, your lordship, while they could able to come by way of appeal, assailing the order of 1/2010, what resistance them to assail the dismissal order passed in 109? Then, your lordship, now here, I will take your lordship.
No, okay. This 109 was decided.
109 was decided, your lordship.
Not on merits.
Page 113.
Not on merits.
Page
Because of
113.
petition under Order 7, Rule 11.
113.
Decided on merits.
Let me finish, sir.
He's asking me, so that's why. If the court asks me, then I'm not to reply.
Okay, 113.
113.
Okay, this is in order.
Order. So I'm coming later on, your lordship, because my 111 has not been completed. 105. That I am now in second 28. I am into page number 29 now.
Yes, page.
Page 29.
Yes.
I have not completed, Your Lordship. Declaration and confirmation of established and absolute lawful occupation rights, titles, interest. It is the same relief which he sought in 2009. Then, to declare the grant permit by Delar number such and such, dated 20/2/1963, passed by the competent authority as such, lawful, effective, operative, and in force. I do not know what does it mean. Then, page 30. That his main contention is that he is the owner of the land by virtue of permit of 1963.
So declaration and confirmation of bona fide, these are same.
Same relief.
Absolute lawful. And restraining of the different. Okay. To declare a ground permit.
Main relief is that
Okay.
declaration of right and title. Then these are, then Your Lordship number, para 30. That whatever his that end second. Oh, end in the matter of end, and then upper portion is not there. Ekbar diba. Kindly, sir, will you please give me your, my, it is not readable also.
Oh.
Achha, I'll take the assistance of my landed senior colleague.
Page 113.
Page 11, no, page 113, no. Page 37.
37?
Yeah, 28, 29, 30, page 30, Your Lordship. Page 30, we are in page 30. Amata বুঝে যাইতেছে না। এটা একটু দিন। Page 30. To declare your to declare initial lawful occupation and enjoyment of possession and otherwise rights, title and interest of the plaintiff by virtue of landholder rights, etc., with absolute occupation and enjoyment as legal and substantive. I do not know. What does it mean? Then, Your Lordship, to declare the plaintiff in accordance with the procedure had acquired the rights as in the status of the landholder and continued till date since 1936. Now here it is 1936. And by settlement rights covered by the grant and permit by the order number such and such dated 20/2/1963 is government grant under the statutory provisions of the Transfer of Property Act 1882, Assam Land Revenue Regulation 1885, Settlement Rules 1870 of Assam Assessment, such and such. Now, out of this act, Your Lordship, only Assam Land Revenue Regulation has been adopted by the state. Now, Your Lordship will appreciate that. May I submit, Your Lordship?
Yes, please.
Your Lordship will appreciate that there are two sets of law. Procedural law, another is substantial law. Now, Your Lordship, procedural law, it defines that procedure. Now, as I have referred to yesterday, Your Lordship, that 1967, that Ratan Singh case, wherein this Honorable Apex Court has held that CPC and CRPC is applicable in the state of Nagaland. In the spirit. But here the question arises, Transfer of Property Act. Now, Your Lordship will appreciate that Transfer of Property Act is an act which is substantial. Now,
yes.
Now, Your Lordship, in Nagaland, Your Lordship is well versed. We are having one that constitutional provision, Article 371A. Article 371A, it states that no act of parliament is enforceable in the state of Nagaland until and unless no act of parliament, until and unless adopted by the state through resolution in respect of herein number 3, land and other resources. Now, Your Lordship, Transfer of Property Act is not applicable in the state of Nagaland. It is a substantial law. Now, if it is being, the statute is being implemented, then Your Lordship, it will be ultravirus to Article 371A. And constitutional mandate cannot be overruled by statute. Anyway, Your Lordship, I will come later on to all this legal position. Now here, I want to place before this honorable court that the filing of this petition, in what manner they filed this suit and one after another. Sir, अपना टमेटो को देखिए ना कि पता अच्छा कोई जो Now, Your Lordship, to cut short, Your Lordship, I also want to save the precious time of this honorable court. I beg to take Your Lordship page 31. That page 31, that 1, 2, 3, third para. To declare the alleged rent receipts in absence of the knowledge of the plaintiff and his predecessor pertaining to alleged tenancy and is or without transfer of occupation and commercial activities and in absence of formal or informal contract, agreement of tenancy, lease, and so the same is bad in law and not inoperative against the plaintiff. Now, Your Lordship, here there another prayer of the plaintiff is that to declare the rent receipt as null and void. Now, besides the other, Your Lordship, Your Lordship, they have annexed also rent receipt in their plaint. So in my copy, Your Lordship, it is a 2011 typed copy. So many has been not in a position to read also, not readable. Now, here that the plaintiff is praying before the court to declare the rent receipt as null and void or cancel or whatever as per. Now he is making payment rent for 10 years, 20 years to the Jame Masjid committee as tenant. Now he has come with the plea to what it is called cancel the rent receipt. Your Lordship, I'll take at least 1 hour more.
1 hour more?
Yes, Your Lordship, because I have to.
We don't have 1 hour more.
So.
Well, that can be cut short.
No.
That
How
can
am
be
I?
cut short, but I am not restricting him, my lord. He is entitled
But
to
then
make
he
his
say,
argument.
okay. But here the question, as per the learned counsel for the applicant, so only because the application was filed under 11D and decision under 11A.
That I will come to
that
that.
also
Also.
you come.
Yes, that is why I have to go through whole file, Your Lordship. There is not only one. After that, they filed the review petition. That also been dismissed. So my question is that here, Your Lordship, there is a section 11 of CPC.
Okay.
Res judicata. In same matter of issue and same subject matter, one cannot file another suit when the suit is dismissed. Yes.
But that plea of res judicata has not been raised by them.
It is court contention.
Court's content. That is why I am challenging the court's order. If you have not raised the contention,
No,
res
Your
judicata,
Lordship, I will come.
and the court
I
decides
am
it.
coming, Your Lordship. That is why I require to
That
go
is my
through.
ground. That is the reason I am.
That is why only that point without going through all this, Your Lordship, because he has filed 3 petitions. Once the main suit is being dismissed, whether the party is having a right to file the second suit.
Yes.
No.
I'll show.
No, I'll show. I am having also. So that is why I require.
How it is maintainable.
I'll show, Your Lordship. I am also having Supreme Court ruling.
No, first of all, the question is, the only question is, what did you ask for? What the application you asked for? Yesterday evening, when we were discussing the case, my lord, my associate friend who has joined just 2 months back, my lord, he made a fantastic comment. He said, my lord, as fresh as 2 months old, he says, sir, ये क्या order लिख दिया कोर्ट ने? इन्होंने तो दाल मांगा था, इन्होंने तो खिचड़ी बना के भेज दिया. That was his remark. That was his remark. Now, what you asked for? Before the trial court, you asked for rejection of plaint under Order 7, Rule 11D. Where from the question of res judicata comes, and how the trial court can decide the question of res judicata without there being evidence led? Well,
Your Lordship,
there is some limit.
This application file under.
It is not so easy, Your Lordship, because there are orders after order.
It is connected. And
Connected. Orders after order is there, Your Lordship. That is CS 1/2009 was filed before this district court, taking the original jurisdiction. Then it was dismissed. Then they filed what it is called review petition. Review petition dismissed. Then they went to other court and filed this. So now here, Your Lordship.
2010.
Yes, Your Lordship, I will prepare what it is called written, and I will give it to the honorable court also.
Okay. So then what is your when do you want then? Next hearing or only written submission will do?
Yes, no, I will have to, because I have to make a.
Okay. So your part, it appears.
No, my lord,
it is done.
No,
my part is complete, my lord.
Okay.
Subject to what my learned friend will say. Then I'll have a right of reply.
Yes.
Then I will have a right of reply. Now, as far as I have understood his argument, subject to correction from him, my lord, he is raising the question that the suit is also barred by res judicata. And therefore, the trial court's finding that this suit is not maintainable, etc., these are justified. This is sum and substance is his argument. Question is, my lord, did you raise the plea of res judicata before the trial court?
1/2010.
In the suit 1/2010, did you raise the question of res judicata? If you have not taken the question of res judicata, regardless of whether how many times I have approached the court. Can the trial court give a finding on it? This is number one. Number two, you in your application, you have only raised the question that this suit is barred under 11D and Assam Land Revenue Regulation. Where is the finding of the trial court that it is barred under Assam Land Revenue Regulation, and under which provision of it? There is a discussion that 154C and 154A, but in the finding part, your lordship has not, the trial court has not recorded any finding that this suit is barred under 154A or C, and therefore the suit is not maintainable. So at the end of the day, my lord, to cut the big story short, what you asked for and what the court has given, that's why I said, my friend said that inhone dal manga tha, court ne khichdi bana ke
This is another issue. This is their internal issue, your lordship.
No, this is not internal.
No. Now you cannot.
This is a very vital bearing. Because an order of the court, your lordship, today your lordship is sitting to examine the order of the trial court. Now, if your lordship is examining the order of the trial court, naturally the scrutiny has to be confined within the parameters of what he asked for and what the court has given.
No. Okay. Anyway, so
the same matter of issue here. There are three cases, your lordship. I will come.
Anyway,
earlier also this
he-
order 7 rule
he is
element D.
here to prove that it is, he want to justify it.
Yes.
No, I am not restricting him.
Anyway,
He is entitled to make his argument.
Okay.
I am not saying that. I am only saying that if he is going to argue the question of res judicata before your lordship, I will certainly take an objection because this is beyond pleadings. There is no pleading whatsoever, neither before the trial court nor before the court at the first instance. So this point cannot be argued as at all.
Okay.
That will be my objection.
Let's see. Okay.
That will be my objection.
Also next day, of course, you will argue, but then at the same time,
I will prepare.
come prepare with that.
I will give you.
The lordship can take it up day after tomorrow. I will join through VC.
I will not be able to come day after tomorrow because
you can also join through.
no. But BC though I cannot.
No, BC.
That day I started.
Because your basically we have heard, but then his BC will be difficult.
Dimapur is very
Because-
poor. No?
Because need to interact also. So yours through BC also not.
In that case, Miller, what I have submit, Miller, your lordship has heard the matter sufficient. At
No.
sufficient length.
I am having.
No. Let me make my submission.
Yes,
Your
sir.
lordship has heard the matter at sufficient length, Miller. Let it be kept as parted.
Hmm.
Whenever date your lordship will fix,
Hmm.
I'll try to come. I'll come
Okay.
over.
Okay, we'll do that and then.
Yes.
Okay.
But after
And I understand, Miller, that this bench is going to continue even in the next week.
Let us hope. Okay, so we'll keep it as a then part hard, no? Okay. Mr. Surajit Dutta, Mr. Plan Senior Counsel, assisted by Mr. V. Devnath, Plan Counsel for the applicant. Also, staff, I have also had Mr. P. V. Paul, okay, Plan Counsel for the respondent number
1 to
12. 11 or 12?
Now 11. No, it was 12.
Okay, 11, no? Staff, 1 to 11 or 12?
Earlier it was 12. One of the
It was
Presently
12.
is 11, I think.
one Helen Khan is expired, so I do not know.
It will be 12.
12,
1
okay,
to 12.
1 to
1 to 12.
All are Jama Masjid. They are the institution.
Okay, start. Hard in part, huh? List is matter again on.
6th.
6th, 4th I am in.
So
I will be on 4th, I will be here.
Then on 4th.
But I will be confined in court number 1. Today also I was so embarrassed in court number.
Okay. When do you want then?
On 9th.
9th.
9th is Monday, 9th.
Okay, let us see Monday.
Monday
9 or 10, huh?
10 your lordship.
10, okay, 10.
10th.
ये तो करें basically.
9.
Okay, 10th. 10th will be little difficult, Milord, because I am supposed to go to Aizol bench on
Okay.
10th.
The tenth,
Yes, that is.
then nine, how it is? Nine also.
Ninth, your lordship,
possible
I am
since
going-
you are
No, 10th I am supposed to fly, my lord. The matter is supposed to come on
Okay,
11th.
then,
If ninth is Sunday, Monday, my lord. If your
Ninth.
lordship takes up on 9th
Ninth, I'm here. Inchigaram.
or on 13th,
13. No, the 13 is
Friday.
Friday.
Friday or not?
12, 12.
12th is Thursday.
12.
Friday probably would be difficult because Friday.
Last day.
Last day.
Uh,
difficult.
12, your lordship.
I'll try to join on 12th in that case, my lord.
Okay, 12.
My lord.
Okay, 12. Okay.
Let it be on 12th.
Okay.
Only thing, my lord, I am just making a submission right now. But if there is a time adjustment, your lordship will kindly accommodate me because because if I am stuck up in some proceeding, some time
Okay,
adjustment.
no problem, no problem. Okay, try to find out the earlier note also, huh? Hello, earlier note also, try to find out, okay? I'll recall it so that I can recollect it. Okay.
No, it must be somewhere in the file.
Okay, it's okay.
His lordship
Next.
recorded the things.
Then next.
For hearing item number 31.
Much obliged, your lordship.
Yes,
Then,
then,
Lordship, let this matter come up on Thursday.
okay. So item 31,
Yes, Lordship.
okay. Both the parties are present.
Mr. V, remove is having it's a consensus.
Okay. On the joint prayer made by both the Land Council for the party, this is matter again on. This is what this matter is about.
It's a very short matter. It's a question of whether an armed forces personnel can be tried without sanction under section
An armed
6 of the
force, an armed force.
Armed forces special provide, yes. So they have not sought any sanction. So that is the only
Thursday.
question. On Thursday, Lordship.
Okay,
What Thursday? No?
okay. Thursday, huh?
Much pleasure.
Okay. Hmm? Okay.